Lords, we've agreed that I would go first purely as a matter of housekeeping, just to answer the questions from your Lordships that I was unable to answer yesterday. There's been some helpful correspondence between the party solicitors, and all but one of the questions now has an agreed answer. The first question was my Lord Justice Newey's question as to how many documents were disclosed by the defendants in January 2023. The answer to that is 6,611. The breakdown is 4,782 on the 11th of January, when the disclosure certificate was served, and then a further 1,829 from Mr. Murray Twin on the 30th. Those are the documents that we know contained a large number of emails to and from Mr. Ginder, which hadn't been disclosed on the 11th. And then the next question in respect of disclosure was, did the defendants comply ultimately with the further disclosure obligations under the 3rd of July order before the trial? And the answer to that, as I said yesterday, is yes, but I've got some detail to put some flesh on the bones. The further documents from Mr. Ginder's devices and online accounts were provided to the other side on the 28th of September, and there were 2,187 of them in total. And then a further tranche of documents from Mr. Cohen and Mr. Skinner's online accounts, in light of the judge's decision on that, was provided to the other side on the 2nd and 3rd of October. That was 1,707 documents. And finally, on disclosure, to correct a point that I made yesterday when I said I understood there'd been some difficulty with the other side accessing these further documents. What we have been told is that the respondents to the appeal, in other words, the other side, were able to access and download the additional documents from Mr. Ginder's devices and online accounts, and they reviewed those. The problem relating to downloads occurred in respect of the further documents from the online accounts of Mr. Skinner and Mr. Cohen, where, for some technical reason that I'm afraid I'm not able to explain, it proved impossible for the other side solicitors to simply click a button saying download all. They had to download each document individually, but they have told us, and we've got absolutely no reason to doubt it, that they reviewed the further documents from Mr. Skinner and Mr. Cohen to the extent possible in the time available by using targeted searches, using document name within the disclosure list and the disclosure ID to locate documents. So they did review those documents, they say, to the extent possible in the time available. And of course, to go back to my Lord Justice New's point, what that means is ultimately, of course, the judge, having said that he wasn't satisfied that there was sufficient time available to complete it all before trial, was proved to be wrong, because it is ultimately, of course, what happened. The only other point to mention that we've been able to find the answer to is what happened in relation to expert evidence at the CMC. And if I could just pass up, please, the skeleton arguments from the CMC. I've given these to my learned friend. They explain very clearly how we ended up, it's one of each, please, where we ended up on that. If
just wait till we've got them, Mr.
Sure.
Rose. Thank you.
If my lords could start with skeleton argument on behalf of the claimants.
Yeah.
At page 12, my lords will see at the top of the page the heading experts. And on pages 13 and 14, my lords will see that the claimants were seeking informally, without any application notice or witness statement, permission to rely on 3 experts, or experts in 3 disciplines. And the key point to note in respect of each, and you see this from 29, 30 and 31, is that they were proposing to adduce expert evidence on the amount of profits that would have been made in each of the counterfactual scenarios. So not expert evidence as to whether each of the counterfactual scenarios would have happened, but evidence as to if each of the counterfactual scenarios had happened, how much profit would have been made in that event. And so that's clear from 29, the expert in residential property whose discipline is accountancy. The expert will be required to identify, 1, the profits, well, that's from development agreement, we can ignore that. 2, the profits that would have been made under the similar agreement hypothesised at paragraph 20E33 of the re-remanded particulars of claim. Then the build costs of the residential accommodation for the purposes of the scenario at paragraph 20E34. And of course, costs are an important part of profit, because if your realisations are less than your costs, then there are no profits. And similarly, 30, an expert in residential properties discipline surveying, this expert will be required to value those parts of the property which include residential property, both the 3rd and 4th counterfactual in respect to the hotel site and Sandman's secondary case on quantum require a valuation to be provided as to residential property or land to be used for the residential property. And then thirdly, in 31, an expert in hotel property whose discipline is surveying, this expert will value the parts of the property which include hotel property, either built or with planning consent, explain the value that a secured contractual agreement with a first-class hotel operator would add, and assess the build costs of the hotel, projected build costs for the hotel having been disclosed in this action by the defendant. So again, it's all about the profits that would have been made in the event of each of the counterfactuals happening, not whether each of the counterfactuals would happen. And the defendant's response to that in the other skeleton argument, defendant's skeleton argument, can be seen most clearly from the passages beginning on page 5, paragraph 14, where having outlined the pleaded case of Sandman, it said in 14, it will therefore be for Sandman to prove at trial that 1, defendants are guilty of the wrongdoing alleged against them, and that 2, but for that wrongdoing, 1 of the 6 counterfactuals would have occurred. Sandman may lead evidence on all of them and invite the judge to make findings in the alternative at trial, but the counterfactuals are mutually exclusive, so the judge can only find 1. And then it said in the event that the other 5 would be rejected, all the costs of dealing with them would be wasted, including the costs of most of the expert evidence now sought. 15, in other words, if Sandman were to proceed on liability and causation, the inevitable result would be that 5/6 of the cost of expert evidence would be wasted. This is not the right way to go about it. This in a split trial would be far more efficient. And then 16, the defendants propose that the trial judge deal with 3 issues, namely 1, whether the defendants are guilty of the wrongdoing alleged against them, if so 2, whether but for that wrongdoing any of the counterfactuals would have occurred, and if so 3, which one of them. If Sandman succeeds on those issues, there should be a further hearing to deal with the assessment of damages with the benefit of expert evidence. This should ensure that none of the costs of the expert evidence will be wasted. The expert evidence would also be more focused. And one can obviously see why that would have had some attraction to the district judge, because none of the expert evidence that was being proposed by the other side related to which, if any, of the counterfactuals would have occurred. It was all simply relating to the amount of profit that would have been made if each counterfactual had occurred. And then paragraph 21 on page 7, the following factors favour a split trial in this case. 1, the need for expert evidence rests on a double contingency in this case, namely that Sandman succeeds on liability and causation. And of course, those are the issues that the judge put into the first trial. And I mean, my lords can read it, but for example, paragraph 3, the 6 counterfactuals are all very different from each other.
Yes.
Of course, the build costs of a hotel would be very different from the build costs of residential property and so on. So, my lord, I hope that clears that up. As I said, there's one final point that we're still trying to work out an agreed answer to, and I'll come back to my lords on that later today.
Right. All right, thank you very much. Yes, Mr. Mallon, we need to pick up the pace a bit. So I would like you and Mr. Lewis to finish by 3 o'clock, if that is possible.
I will certainly strive to do so, my lord. Yes, thank you for that indication. I haven't had much of an opportunity to look at those skeleton arguments. You got them just before the call. That's no complaint. Just an observation about where I am on them. But actually, it does seem to me that there's something in there that really crystallises a couple of the points that I was trying to convey yesterday. So I wonder if we could just start with those skeleton arguments, and in particular, the skeleton argument on behalf of the defendants, and the bit that my learned friend took your lordships to, which is at paragraph 21.
Yes.
And there's 2 points arising out of this. Your lordships will recall that one of the issues, and in my submission quite an important issue, is the question of the relationship between liability and causation and counterfactual scenarios. And my point to your lordships was that with the claims of tort, obviously causation and loss are required in order to constitute the tort. And I said that was made out, and I showed the court where the judgment was, and the fact the judge had inferred value from the surrounding circumstances, sufficient value. Of course, he wasn't quantifying it, but sufficient value to establish that loss had been caused in the manner that it needs to be caused to make complete the torts of conspiracy, etc. Now, just to really sort of nail that by reference here, I think we can see from paragraph 2, it would also be disproportionate. This is coming from the defendants, to risk so much money on the whole exercise at this time. The hotel site is currently estimated to be worth around 2.4 million. Now, that's coming from the defendants at the time. We're not saying, therefore, one stops there and you can say, well, we want damages of 2.4 million. But if the inquiry is, has there been proof of damage to a sufficient extent to constitute?
I mean, there's no way you would get damages to 2.4 million. You're not entitled to the site. You're only entitled to 50% of the profit in the event that the site's developed or flipped.
Absolutely, but this is an indication of the value of this project. That's all I'm trying to say, my lord.
Right.
So
it's not, with respect. It's the value of the site, not the project. I mean, if it were to cost, let us suppose, £10 million to build a hotel, but you could only sell it for £10 million, there would be no profit because the site's already been acquired.
the hotel site will be valued as a business. That's how it's valued. 2.4 million will represent some experts, and I gather that this is from a valuation expert's estimate of what profits can be made that therefore feed into the valuation of the hotel. We were entitled to 50% of those. I am not saying, my lord, that the value of 2.4 million is the conclusive valuation and that's what we want. All I'm saying is that in terms of getting over the threshold of proving that we have made out the tort of conspiracy, for example, or procuring a breach of contract, that is more than sufficient evidence, and it supports the judge's finding that by necessary inference he could infer that there had been a loss. That's all I'm saying. I'm not trying to quantify that loss.
Well, hear what you say.
Yes. And the other point, though, is this. I mean, this goes really more to the heart of the matter. If you look at paragraph 21.1, you'll see that what's written there is the need for expert evidence rests on a double contingency in this case. Namely, that the Sandman succeeds on liability and causation. The costs of the expert evidence proposed by Sandman and the extra court time that would be required to deal with it are likely to be considerable. So the premise is that those contingent, those counterfactuals are part of the liability question. So what is being said here is that this was indeed, as one would expect to be fair, a liability quantum split. It's just that it was erroneously considered that those counterfactuals formed part of the liability analysis. They didn't, and they never could have. Now, it may be said, well, that is effectively what counsel for the claimant was saying as well. And that may be so from the skeleton arguments, haven't had a chance to look in detail, but the implication of the passages that my learned friend took you to suggests that that was at least the premise of his position.
Well, is that right? I mean, in paragraph 16 of this skeleton argument.
I wanted to go to that actually, but yes.
Yes, all right. Well, you go to it then.
What he says there is that defendants proposed trial judge deal with three issues, namely whether D's are guilty, as he puts it, of the wrongdoing, and if so, whether, but for that wrongdoing, any of the counterfactuals would occur, and if so, which of them. That aligns completely with what he's saying in 21.1, namely that those determination of those issues is a part of causation of loss. In other words, in order to make out liability in the round fully, you need to establish that, and that's wrong.
Well, whether it's right or wrong as a matter of legal taxonomy, procedurally, that is what the defendants were proposing, and that is what the district judge ordered.
But it's not just a question of legal taxonomy, my lord, it's a question of a relatively fundamental mistake, however that's come about. I'm going to come up in a second to address.
I don't understand why it's a mistake.
It's a mistake.
The district judge appears to have accepted the submission that the scope of the inquiry, particularly as regards expert evidence, would be much more limited and therefore much cheaper if the trial judge were to find which of the possible counterfactuals would have happened.
But that presupposes that on a case of this kind, there is any need or indeed any possibility of making that inquiry. So first, as to need, there is no need to make that inquiry. We've already seen the judge here has made out the tort and the loss on the basis of what he had before him, not some hypothetical analysis. And let's pause there for a second. It's not even really a counterfactual analysis, properly so called, because it's not what would have happened but for, although that's the terminology that's used. It's asking yourself the question, which of a number of different scenarios could have happened in the future? That's not the same as a counterfactual inquiry.
So are you saying then that at the second trial, each of the 6 counterfactuals needs to be investigated and each of the 6 counterfactuals requires expert evidence as proposed at the CMC?
My lord, if I was starting this matter with a blank sheet, I'd say you wouldn't come anywhere near an analysis of that kind. All I'm saying to the court is this.
Well, that's your pleaded case.
Well, it's pleaded that those are the counterfactuals by which the court should quantify loss. Yes, I accept that. That is the pleaded case. But the position we're in now is that we're at the end of a liability trial. In my submission, paragraph 21.1 fully supports the proposition that what was intended, albeit via, I would submit, an erroneous route, but what was intended to be tried was liability.
All right, well, we've got that submission.
Just to be absolutely clear, would you wish at the next trial to be able to advance a case that any of these counterfactuals would have occurred?
That would not be a factual case. If I were dealing with the matter, as I say, with a blank sheet, not confined by or constrained by whatever the court might oblige me to do, I would say the correct principled approach would be to say, we have now identified what the loss is. It is the loss of the rights to the hotel and the profit share in the share in the profits of the hotel. How do we value that? That will be done by reference to a series of considerations about if the hotel has not by then been developed, what could happen in the future?
So putting it differently, would you be content, given that position, to proceed on the basis that at the further trial, it is not open to you to advance a case that any of these counterfactuals would in fact have occurred?
Those counterfactuals, my lord, it's very hard for me to answer that question because it's a matter for expert evidence as to how the loss of those rights is to be quantified. The expert won't be looking at the matter on a balance of probabilities, but he will be looking at the possible further outcomes.
So in other words, what you would propose to, the case you would propose to advance at the second trial is that your clients have lost a right. That right is a share of the profits in the event of something happening, and the task for the valuer is to value that right.
Is to value that right.
Yeah.
Yes. And that is orthodox, in my opinion, in my submission, I should say, as a matter of approach. Normally, you'd ask yourself the question, or the court would ask itself the question, well, when should I value that right? Often it's at the time of breach. Sometimes there's an argument that it should be at the time of the hearing.
Well, I understand the argument. Yeah.
I don't know, my lord, I can assist further on in relation to that question. I have not got submissions, as it were, try and bind us. Of course, any decision your lordship's made about this could impose such conditions as it saw fit. But what I'm trying to do is approach it as a matter of
I follow the framework of what you're saying. You say you lose the right, you value the right. And so it really doesn't matter whether any of these counterfactuals would in fact have occurred. That leads on to the question, are you content to proceed on the basis that it isn't open to you to argue on the facts that any of these things would have occurred, but that you're not willing to?
Well, I've got no instructions to that. That would be a fairly significant binding of the rights of my client. If your lordships felt that that was a necessary part of any decision, then of course conditions could be imposed by the court as opposed to my making that concession. I'm not trying to squirm away from that, my lord, but it's a rather difficult
Well, I mean, if
question.
your primary case is that what has to be done at the next trial is to value the right, then an orthodox valuation approach should be for the valuer to consider all possibilities as possibilities, not as facts, and take account of who might be in the market to buy such a right.
My lord, I agree, and that is our position, that is how it should have occurred. Now, I recognise, of course I have to recognise, that that is not how it occurred. And in fact, that at least in part at the CCMC, even the defendants' own legal representatives are not putting it in that way. But that's the point. We get to the point that at trial, and we have a trial judge who looks at the matter, and he says this has gone wrong. This is not how it should be. This isn't the correct approach to establishing a liability.
I don't think it is what he said. He didn't say what's going to happen next time round is that there's the value of the right is to be valued. He is contemplating that at some future trial, one or more of these counterfactuals will be proven.
What I mean is he says, and we'll see what he says specifically in the judgment in a moment, that things have gone wrong in the sense that this is not part of the liability trial, and therefore I'm going to make the directions I do. So the question is, what power did he have to do that, if any, given the existing order? And if he had a power, in what way should he have exercised it, and did he exercise it correctly? We say that he had the power of a trial judge to deal with the issues in front of him as he considered appropriate. So he had a wide discretion as a starting point, we say. And we say that wide discretion is recognised, not created by, but recognised at least by CPR 19.9.1. But we also, of course, recognise and entirely accept that power has to be exercised judicially. And we say that's why a material change of circumstance in the exercise of a power of this kind is generally considered or required in order that that exercise of discretion be considered judicial. We see that on the authorities in relation to CPR 19.9, and we know it's there in the sort of Tibble's line, and I accept that. But what I say is that that is the general position, and the vice that is aimed at is the second bite of a cherry. What you can't have is someone, an order being made by a judge, particularly in the face of an opposed application, and then that person simply comes along a month later, as we'll see in the relevant case, and saying, I want to apply again. There has to be a material change of circumstance. We say you have to look at the facts and the circumstances under which the discretion is being exercised for two things that come to the same thing. Number one, whether in fact at the level of a case management decision being made by the trial judges to the manner in which the issues should be dealt with, whether that actually, as a proper exercise of the ostensibly unfettered discretion, requires a material change of circumstances at all. Or two, and arguably more cogently in a way, but running in parallel, two, whether in those circumstances the better view of those issues that is available to the trial judge is itself a material change of circumstances. In other words, if one had to prize this exercise of discretion into a box, that box being material change of circumstance, it could readily be said that the very improved position, if you like, of a trial judge, there ready to try the issues with all of the material presented to him, is such as to constitute a material change of circumstance. And we can see that the damage control case, properly relied upon by my own friend, lends support to that suggestion. So if we look at, it's behind tab 11, and your lordship saw this, my own friend took you to it, decision of Mr. Justice David Richards, damage control. You'll recall that it was an application to rely on expert evidence, and it was made very late in the first place, and it was refused. And then 1 month later, a new application was made, and this was where the fairly obvious 2 bites of a cherry point was made on the facts of that case. But if we look in the judgment to paragraph 22, which is at internal page 149, your lordships will see this. It begins with that Mr. Margolin submits.
Yeah.
And then we just go down 4 lines and it says this, that of course there may be circumstances which become apparent to the trial judge, such as the way in which the parties are putting their case, or indeed the way the trial judge views the issues, which may make it appropriate for him either to refuse or to hear expert evidence for which permission was previously given, or indeed to allow in expert evidence in circumstances where permission had previously been refused. But that is in a case where there has in substance been a material change of circumstances. The nature of the case appears differently at trial than it previously appeared. That is not the case here. Now that is the very submission we're making, not as regards expert evidence. That's nothing other than coincidence of words. We are concerned here with what has become apparent to the judge. And in my submission, what has become apparent to the judge is that the manner in which the case, at a very early case management stage, was directed to be tried could not work. And therefore, he, conducting a proper analysis of the situation, took one step. Now, he didn't go on to then deal with what should happen at the quantum trial, but he took the step of saying, I will resolve liability on the basis of the material before me, and these issues of the counterfactuals will go off to any quantum trial. Yeah. And in my submission, my lords, that was not only an appropriate exercise of the trial judge's discretion, it was really the only thing he could do. And not only in the circumstances that were actually before him, but just imagine anybody had tried to prove those 6 counterfactuals on on a balance of probabilities basis. When you're talking about actions of other people, we all know from Allied Maples and the proper doctrine of loss of a chance that we discussed yesterday, when that becomes an element of causation within the tort itself, we know the significance of the actions of other parties and the usually great difficulty in proving beyond to the level of a balance of probabilities what would or would not have happened or what they would do. That was always in my submission a trial structure that was not going to work. The judge has simply recognised that. I accept entirely, but he hasn't followed that through in, well, exactly how should this quantum trial go forward, but what he has done is said, my task here, confronting what I do, is to establish whether there is liability. And liability there includes causation, just as actually the learned district judge anticipated that it would. It's just that a wrong view was taken in my submission of what it included.
Right.
And those are my submissions, unless there's anything else on appeal 2.
Right. So now we move to appeal 1.
I do indeed. Let me just get the authorities away. I'm going to take it just by reference to each ground in turn. And of course, ground 1 is concerned with the unless order in relation to paragraph 4b. And I'd like just to take a look at this ground of appeal before we go any farther. I think that's in the core bundle at page 319. Your Lordships will see that at 319 itself, ground 1, the judge erred in law by finding the appellants breached the unless order by serving the schedule on time but with items missing from it. He should have found that although the schedule was incomplete, so note there is no challenge to the finding that the schedule is incomplete, it had nevertheless been served in accordance with the unless order. And then we see the 3 sub-grounds to that, where that proposition is explained. The first is, he applied the wrong test. He should have effectively applied the test in the Real Credit Bank case, not QPS. And his conclusion there is, because it was not in dispute that the schedule had been prepared in good faith and was not illusory for the purposes of the test. So what he's saying is the judge should have found that there was compliance with the order because it had been served in good faith and wasn't illusory.
Well, Mr. Robbins has put the case rather differently. You didn't object to his putting it that way. What Mr. Robbins is saying is the judge didn't consider exactly what it was that the defendants had been ordered to do.
My lord, I'm just reading to your lordship the grounds of appeal. I didn't object. It's not for me to keep on jumping up and getting in the way. I make my submissions now.
Right.
And my submission is that this is the basis of the appeal, and this is the basis upon which it should be determined, and it must fail. And it must fail because of what my learned friend said, in effect. Because he said, and I agree with this, and so I note as your lordship from paragraph 40 of the Atrium case, that what one does is look at the order and decide whether it's been breached or it hasn't been breached.
Yeah.
But if you do that and you have someone in the grounds of appeal saying that the schedule was incomplete, notwithstanding that, because they had a subjective belief that it was complete, then there has been no breach. Then in my submission, once you take that test away, you're just left with the fact that the appellants have accepted that the schedule was incomplete. And that must be...
Were they required to serve a schedule that was perfect, or were they required to serve the schedule with which they had been provided by Concilio?
Well, the word incomplete, my lord, by its nature, means that it's not complete. Complete must have reference to something. It must be defined by reference to something, and that something is obviously intended here to be the requirement of the order. What else, I ask rhetorically, not to your lordship, of course, what else could it be?
Well, if we look at the order, we'll see what it might have been.
I'm coming to the order. Of course I am. I'm not going to sit down after saying what I've just said on
But if you say, well, there's effectively an admission of breach, we have to look to see what complete might mean in the context.
Well, I was looking for a moment before that at what the appellants clearly meant when this was drafted. And my Lord Justice Lewison stepped in to say, well, I didn't object, therefore already, if you like, recognising that I might be saying, well, there is in effect an admission here and there's no grounds for this appeal, which I am saying. I'm not going to not, therefore, deal with it substantively, and then it'll be a matter for your lordships. But I do say that a level of formality around these things is required if someone advances. And by the way, this is completely matched in the skeleton argument. There's no question about it. It's just the test. And there's an acknowledgement of incompleteness, and I say that's an acknowledgement of breach. As I say, a level of formality is required. You can't advance via formal documents such as a ground of appeal, a method of approaching the case, and then simply jettison that. Not least when a critical issue in any analysis here is whether in fact the schedule was complete or not complete. That's the terminology that has been used. And there's an acknowledgement in my submission, call it a concession, whatever it might be, that it was incomplete. And therefore, when you apply the right test, you get breach. Yeah. Whereas if you apply the wrong test, you sort of save yourself. That's the point I'm making. And I do urge that one should not simply go, well, I know, but that's not how it's put now. There are obviously
I understand.
Dividing lines on these matters, but this is a pretty high level of formality in my submission. So, the reference, by the way, for your lordships, on the skeleton argument, which supports the way it's put in the grounds, is paragraph 33, which is at CB 339. So these submissions are without prejudice to that primary contention. So now it's said that there was no breach because instructions were given and the schedule was served. In essence, that bypasses any concept of completeness or not, or otherwise. You simply serve the instructions or produce the instructions, something comes back, and you serve it. So again, that goes back to the point of what's the force then of the acknowledgement of incompleteness. So we agree, just for absolute clarity, that the proper approach is to look at the order, see what the obligation is, and decide whether it's been breached. And if any support for that were needed, it's paragraph 40 of Atrium, judgment of Lord Justice Lewison. Now, also, the court may recall from looking at this, I don't think we need to turn this up, that there are circumstances under which that decision isn't quite so clear, and that's when the obligation imports a form of judgment. And that will often be seen, for example, in the production of a list of documents, because someone's got to decide what's relevant. And the court in Atrium said, paragraph 50 is the simplest reference to pick this up, the court said that a margin of appreciation would be given in those circumstances, so that it wasn't an absolute right and wrong, well, a document's missing and therefore, because the obligation, the thing that was mandated, was the exercise of a judgment. And that's how it stands on Atrium. But that's not the territory we're in here. We're in a do or don't do, and therefore no room for margin of appreciation. And I think, my lord, this goes back to the question about completeness. You might have a situation where it would be possible for a party to say, well, and the list of documents example comes to mind, the party could say, well, yeah, all right, on reflection, those documents should have been there. So in that one sense, it was incomplete. But then your lordship's paragraph 50 point from atrium would come in and say, well, actually, there's a margin of appreciation. So in those circumstances, we can see that a proper judgment was exercised, and the exercise of a proper judgment was the obligation contained in the order. But as I say, we're not in that territory. So let's have a look then against that background, again at the actual obligation. So that's in the supplemental bundle at page 14, if memory serves me. The orders at 14, the specific obligation is 16. So, 4b, the starting point is, it follows also the words also instruct the e-disclosure provider to produce a schedule containing the following details. One, the file name of any document deleted. So just pausing, that's probably a minor point, but any document deleted. So it's comprehensive and oddly specific. There is no judgment in there. It's any document. So there's no question of looking for relevance or anything of that kind, right? It's just any document that's been deleted or modified following service of the initial order. 2, the file type of any document identified, the date and time of such modification or deletion or access of the SG device. So this obviously pins us now to the regime that has been implemented by this order generally, because without that definition, at that stage, you'd be going, well, what document? So that's what pins us to the intended regime in this under this order. And that's picked up because any identifiable user or profile undertaking such a step, so that relates us back, such a step, and then any identifiable steps taken during such access of the SG devices, and that's defined as the schedule. So the schedule is to be produced from the same pool of documents that is created by or identified by paragraph 2 of the order. That's the purpose of the order. Otherwise, you wouldn't have a clue what documents you were looking at. And little 1 defines the time frame, and then at least 3 and 4 make clear what the source of the documents you're looking at, and such ties them together. And if you look at, just very quickly, the words of the instruction letter at SB 233, so in the same bundle, SB 233, this is the letter of instruction. I hope I've got the correct version of it. I think I have. Letter from Jury O'Shea beginning at 232, and you'll see that just opposite the first hole punch, in accordance with paragraph 4b, you're instructed to produce a report setting out the steps you have taken, and then it goes on. Produce a schedule containing the following details: file name of any document, file type, etc. And going down to 3, date and time of such modification, or access of the SG devices, which is defined as any devices including electronic storage media delivered to you or online storage accounts that you are given access to under paragraph 1 above. And paragraph 1 relates back to paragraph 2 of the order. So you can see how it all ties up. That's Jury O'Shea. They're interpreting the order. And that is consistent with how I say that order should work. But of course, it's premised on what's coming out of the process in paragraph 2. And then the word is defined, the schedule. So, as I say, it's not like a reasonable search. There's no margin of appreciation here. There is either a schedule, capital S, or there's not. And that's reinforced by the repetition of the schedule containing the details under 4B1 shall be provided to these sols. To the extent it was necessary, it makes absolutely clear what this schedule is. And then the defendant...
There are 2 points here, aren't there? You've taken us through what the schedule is supposed to contain. What the defendants have to do is not produce the schedule. They have to give instructions to the e-disclosure provider to do this.
Yes.
And they have.
Those instructions, my lord, they cannot just be empty instructions. They have to be instructions capable of achieving the goal in 2, because there's a direct link to it, paragraph 2, so as to allow a forensic image to be taken of their contents, including any deleted items which can be restored.
It seems a bit rich, if I may say so, Mr. Mallin, that when your solicitors agreed the form of the instructions, you can now say that they are deficient.
Oh, well, actually, I was going to come to that point, and...
But just hang on a minute, because the second point, which you have just made, may be a different point, and that is the schedule incorporating the details under B1 shall be provided. So that, you may say, tells you
what's to be provided.
what's to be provided.
I agree,
But
absolutely.
4B1 is the file name of a document. It doesn't require anything else to be provided.
Right.
Is that right?
Well, in context, my lord, the file names, the file name is the name of the files of the deleted documents that have been found pursuant to the process of generating documents or identifying documents created by paragraph 2. I don't think 1 stands in some sort of isolation that you're supposed to...
I'm just looking at what the order says.
Yes, but you have to read the order with the other provisions of it, my lord, and you also have to look at what the defendant's solicitor said it meant, just to see if there's any doubt there. They were quite happy that the process here is to identify to give these details in relation to an identifiable set of documents. That identifiable set of documents is the set of documents that must be produced pursuant to paragraph 2.
Yeah.
Or the image of those documents, I should say, to be more precise. As that was never produced, there was no conforming image, and there could be no schedule, capital S, containing those things. And that brings us back to the whole notion of completeness. Because if it is accepted, as it is, in their grounds of appeal and skeleton argument for this appeal, that the schedule was incomplete, it must be incomplete by reference to something. If it didn't have a mandated minimum requirement of what needed to be in it, there'd be no notion of incompleteness. You couldn't serve an incomplete schedule. It has to be incomplete by reference to something. And and the only thing it can be incomplete by is by reference to the terms of the obligation. And it's that recognition, in other words, that has caused the defendants up until yesterday to be jumping through these hoops of it's about subjective intention. We did it in good faith. Your lordships have seen that,
Yes.
not just in the words of the ground of appeal, but also in the skeleton of evidence and so on. And then there was also a move towards reasonable belief and those kinds of concepts. All of those were designed to get round what they recognised as the consequence if they didn't do those things.
So can I be absolutely clear? Which bit of paragraph 4b do you say was breached?
The primary or the most substantive obligation is to produce a copy of the schedule, capital S. And they did not do that.
No, but they didn't have to. They had to instruct the e-disclosure provider to do it.
And then they will provide a copy of the schedule to the claimants. That's the penultimate line.
Well, as a matter of wording, it says we have to instruct the provider to produce a schedule. The
And
The
that,
defined term, the schedule, seems to relate to what is produced, and then you have to provide a copy of what is produced to you.
that's, with respect, my lord, that's the mechanistic way of looking at it. But you have to look at what the instructed should be within that schedule. It's not just any schedule, it's a schedule by reference to defined terms and connection directly as recognised by the defendant's solicitors back to paragraph 2.
I mean, can I be clear then?
Yes.
You say there was a breach of the obligation to provide a copy of the schedule to you.
No schedule was provided, I will say.
So there was you say the breach you allege is a failure to provide a copy of the schedule because
And
there
also-
was no schedule.
There was no schedule and there weren't instructions to provide a schedule capital S. There
Well,
were-
that's a different point.
Is
So
it?
can I just separate them, please? There may be two possibilities. One, there was no schedule, therefore they couldn't provide you with a copy of it. Two, and then this is the second point you're making, they didn't give instructions to produce a schedule. So
in one sense, one follows from the other, but I'm perfectly happy
it seems to be different points because there are two different obligations. One is to instruct somebody to produce a schedule. You say they failed to do that?
They failed to do that because the obligation is to instruct them to produce a schedule containing any document located upon investigation of the relevant imaged body of documents arising out of paragraph 2. And so if that can't happen because there's a breach of paragraph 2, then the instruction to do it equally is not an instruction to produce a schedule because a schedule simply can't be produced. And by the way, there's a interesting point of fact in relation to that. Of course, they also accepted in due course that when this is the defendants, when their failings in relation to paragraph 2 were recognised, and so they had to incorporate more accounts within the image or identify within the image more accounts, they accepted they had to serve a revised schedule and did in fact serve a revised schedule, albeit not until the 2nd of October. So throughout this case, there has been an inextricable link between your ability to produce a schedule, capital S, and the production of the correct forensic image for the purposes of paragraph 2 and the various steps within paragraph 2, such that if you go wrong at paragraph 2, the schedule and the instructions in relation to the schedule can never be compliant. And that, with respect, that must make sense because paragraph 2 is the starting point in order to do other things.
And of course, with paragraph 2, not only is there not an unless order attached to it, but it's not directed at anybody but the defendant.
Well, we'll come to that, the latter point specifically shortly, my lord. That's a little bit misleading, with the greatest respect, not coming from your lordship, of course, but as a point that's been made. Again, not a point made before, indeed quite the contrary point before, and there's a very simple explanation for it, and I'll take your lordship to do it. But we know the circumstances under which there was no unless order. My learned friend said, oh, that was just a mistake yesterday. Again, I hope there's time to do this, but I can take you to exactly what was said in the witness statement of Ms. Williams. She said she intended to say that everything had been done as it was supposed to be done for the first report. And that's obvious because why would a party in the position of the claimants go for an unless order here in relation to the schedule, go for an unless order here in relation to paragraph 3 and not for 2? And without waiving any privilege, I can tell you, lordships, there was no conscious attempt to do that. It has never really meaningfully been challenged before that the absence of unless order in relation to 2 was due to that communication. The judge accepts that. He finds that in his judgment. That said, quite correctly, the judge said, but I can't treat paragraph 2 as though it had an unless provision attached to it. He was quite right to do that. But the point is, in my submission, it would be a rather extraordinary outcome if you had the paragraph that was designed to define the body of documents that you were to investigate. If there is effectively acknowledged and at least found breach of that, such that that didn't ever happen, that body of documents was not identified in the way that it could, and then you have two subsidiary paragraphs, two further paragraphs, I should say, that depend for what's being done on that, as you would expect, because step 1 is find the documents. Now let's see what we do with them.
And
how you could not
just remind me of the chronology. Miss Williams said what when?
I'll just have to find my reference on this, my lords. Got a note to myself to pick it up, but I think it was at a bit of a later stage. I wonder if I could get some assistance on that. I'll just get the reference behind, my lord. I did have it. I was looking at it just this morning, but I got it at a different stage.
The emails.
Not the email, the witness.
143.
143, thanks. I'm told that's 143. That must be in the supplemental bundle, I think. Yes, it is. And this, your lordships will see, is the 6th witness statement of Ms Williams.
So this witness statement was given on 29th of August, yeah.
And you'll see there's a number of sub 21 points, as it were,
Yes.
on page 143. If you go down to 2111, you'll see on 24th of July 2024, I emailed Shakespeare Martin informing them that images of all devices have been taken. And that's the point my learned friend made, sort of rather construction of the letter. And then we look, I said this because of the confirmation I'd received from Concilio on 18th and 22nd July. I mistakenly understood that Concilio had imaged all of the third defendant's online accounts.
Well,
And
how does what Miss Williams said on the 24th of July influence what your side is asking for on the 3rd of July? What you told us just now was, in the light of what Miss Williams said, you didn't seek an unless order to be attached to paragraph 2. But I don't at the moment quite follow how what she said on the 24th of July could have influenced your decision on
I
the
entirely
3rd.
understand the point. And
The unless order was the 31st of July.
that's right. Thank you. I thought I was going mad for a moment there. The unless order, my lord, was the 31st of July.
Oh yes, right.
Now, I had lost sight of that just for a second there
right.
in a momentary panic. So you can see that this is just
Yes, I
days
see.
before.
Yeah.
And I just wanted to finish with that, on 2112, I think it's an addition. Yes, she says, right at the bottom, I had no reason to believe that Concilio had not imaged all of the online accounts, particularly given the volume of response documents, etc. So, in my submission, that position was clearly being represented, and it appears on the genuine belief of Ms Williams at the time, not suggesting otherwise. But the point is that in all the circumstances, in any case, when you look at how these matters were progressing, the idea that they'd have sat down and gone, well, we won't apply for an unless order in relation to paragraph 2 is somewhat fanciful, and we don't even need to go there because there is that explanation and the judge has made that finding.
Yeah.
And so the point I was making though is if you've gone wrong at the base there, it'd be very surprising in an order structured as this one is if you could do the other things without breach. Because you've got to produce certain defined things coming out of that that universe of documents.
Yes.
And so if we just look against that analysis to what the judge said, good, that's at CB 24. I think it's as 56 running into 57. Yes, he if you see the final words of 56 at the top of 24, just beginning the question of whether the schedule served complies with the requirements of the 3rd July order is equally capable of objective assessment by the court by looking at what the 3rd of July order required the schedule to contain and then at the schedule served to see if it contained what the 3rd July order required. Well, in my submission, that's a very well put together summary of the task before the judge. And he was able to resolve that task readily because he said the defendants accept the schedule ought to have contained details of documents which it did not contain. Even if I had accepted the defendant's case that only 2 email accounts of Ms. Ginder had to be imaged, the schedule served was still plainly incomplete and insufficient. And in my submission, well, that finding is completely unimpeachable. Filing, serving a copy of a schedule that doesn't contain that which it ought to contain is no different from any other failure to perform a fixed obligation, not a judgment obligation.
Yes.
Just to repeat that point.
So just proceeding that for one moment, the scheme of this is that the defendants have to instruct Concilio to produce a schedule. You say, reading the order in its context, that means that they had not merely to give the instruction, but they had to produce a schedule which complied with each requirement.
Well, they plainly did have to produce the schedule because they had to, they may not have physically produced it, but they had to provide a copy.
But they had to provide a copy of something that complied with every requirement.
Yeah, absolutely.
So just to be specific, it was in every respect satisfying 1, 2, 3, 4, 5 in paragraph 4b.
In relation to the documents that had to be, the sources that had to be searched. Yes.
So if Concilio had misnamed a file, then the unless order took effect.
I think most sensible judges, if they were confronted by an application at that point, would apply the de minimis rule, I suspect. I don't know. It depends what it would look like. But, my lord, the point is that we can look at hypotheticals of a different circumstance. But what we know here, and just look at the conclusion of the judge.
Just before we do, so I'd like to bottom this out.
But
I mean, it's not an irrational scheme, because if you're entrusting something to a third party, you don't necessarily want to find the unless order has taken effect if there's some failing by the third party. But it is your case, is it, that any failing by the third party in respect of these 5 matters, at least if it's more than de minimis, means the unless order takes effect?
Yes, quite simply. But let's put that in some context before, as it were, simply residing in that answer. When a solicitor, for example, produces a document, a list of documents, whatever it might be, his client is responsible for the outcome of that. No client, or certainly these days, actually engages in the process of producing a list of documents. But of course, the clients, the underlying clients, are held responsible in terms at least of their conduct of the litigation by the proper performance or otherwise of the solicitor. Now, how does disclosure, for example, take place in the modern world? It takes place very often by means of disclosure experts such as Concilio and IT experts. In my submission, as the learned judge found in relation to S2, those parties act, to all intents and purposes, the agents of the client. And they're behind, if you like, that wall of, the court can't start looking into whose responsibility that was. The question is, what's the outcome? and the outcome is a schedule that doesn't conform. I think the thrust of your lordship's question goes to this, if I may say, and forgive me if I get it wrong. It's about fault. You're saying, the thrust of your question is, well, wouldn't that be harsh if the consequence of being, the strikeout consequence were there when the task in question wasn't even done by the defendant?
And that feeds into the suggestion that it wouldn't be an irrational scheme, that the obligations in respect of which you had unless order default provisions were to instruct and to hand over what you've been provided with.
But it would, my lord, if you don't mind me saying, because you've got the court has no coercive power over concilio at all in this circumstance. So concilio could just go out and do anything. S2 could go out and do anything. But they're doing things as the delegated party, the party delegated to do them on behalf of the lay client, just in the same way that the solicitor is. In my submission, there can be no meaningful distinction in principle. The reason, or one of the reasons, as a matter of policy, why the court doesn't accept a failing of a solicitor as a good reason, for example, in circumstances like this, is because you simply can't. You have to identify the solicitor with the client, because otherwise, even if there weren't a question, strictly speaking, of agent, which of course there is, but even if there weren't, it would involve the court in all sorts of pointless inquiries into, well, where did this all break down? And in fairness, we see some of that in this case. And the court can't be doing that. What the court has to do is look at the outcome and say, is that in compliance or is it not? I wonder if you'd excuse me a second.
Yes.
Well, as just a point of information, my lord, it was our original intention that we should have our own expert doing this exercise.
Yes.
I think you may have seen that.
Yes,
but the court
indeed.
decided it should be concilio. But it's the point the judge made as well, in addition to this, the practical point, that when you're mandated to give instructions, it isn't enough, or depending on the nature of the instructions, of course, it isn't enough for a solicitor simply to say, well, this is what the order says, because you've got a solicitor who is legally qualified and understands matters, and an order can be perfectly clear to a solicitor because the solicitor can follow through the definitions and how the various provisions interact, but that won't be clear necessarily, indeed be surprising if it were, to a disclosure expert or an IT expert.
Well, so do you challenge what the judge says at paragraph 60?
60.
60, page 24. He says an instruction was given in accordance with paragraph 4b.
Well, I would, but I don't have to challenge the outcome of what the judge says, because the judge finds, as we see in 56 to 57, that the service of an incomplete
Yeah,
schedule.
I follow. But you
So I would challenge that, yes, but I don't think it's necessary from a formal point of view, because the outcome is the same.
right.
That's ground one, then we have to get to the question of relief from sanction, assuming that we are right that there was a breach. And so I'd like to start, if I may, just by looking at what the judge said. So if we go to the judgment at core bundle 26,
Yeah.
para 69. Your lordship sort of picked up, just before I look at this, there's a suggestion, perhaps more than a suggestion, in my learned friend's submissions, and indeed in Mr. Atkins before him, that the judge went wrong in looking at the consequences of the schedule being, as we say, incomplete, indeed as they said, incomplete. And that he mixed it up somehow with disclosure issues generally. And so I think it's worth just having that submission in mind as we look very quickly at what's said here. So 69 and 70, this is the judge summarising in effect what Mr. Atkins said, and your lordship can see that a lot of what Mr. Atkins said was in fact directed towards disclosure. For example, 3/4, 2/3 of the way down, 69. On that basis, the skeleton argument suggested the disclosure would be completed by the 6th of September, with the possibility of a small balance of documents imaged by Concilio might be disclosed shortly thereafter. Just a point in passing on that, this is one of many examples of the kind of promise around the timing of disclosure that was made. And these promises, which were never kept, we know the dates of disclosure, are important when one is considering how entitled was this judge. Was it a proper finding of his that the disclosure process won't be completed properly and there will not be the possibility of a fair trial? What he's being told in that respect is a very important part of that analysis, much more important than to say, well, with the benefit of hindsight now, we did this and we did that, and this could have happened. What one has to look at, I'm jumping ahead slightly, but while we're just touching on that, what one has to look at is what was the judge confronted by? Was his finding, confronted with what he was being told, a correct one? That's going to the question of the fair trial, etc., broader point. But just to touch on that for a second. And we see the same theme, though, in paragraph 70. Mr. Atkins, and this makes my very point, in contrast, Mr. Atkins' supplemental skeleton, 1st of September, he said, using the agreed search terms, 444 new documents have been identified from that account. He accepted that was more than expected. And it goes on, manual review and so on. And this was, of course, your lordships will see 3 lines up, was on the basis the documents from the online storage accounts of those 3 parties would not have to be disclosed. He proposed witness statements could then come 2 days later. So he's focusing on disclosure. He is. Now it's said that the judge can't understand why the judge got confused. The judge didn't get confused, but this is where disclosure issues are coming from. Now, by contrast, if I may say, my submissions are then summarised in paragraph 71. I said that the default was both serious and significant, because of course that's the test we're on. I should have identified that. The original obligation was imposed by the 3rd of July order. Since the 3rd of July, defendants have been guilty of serious failures to comply with the requirements of that order. The 3rd of July order required the schedule to be served by 19th of July, so worth bearing that in mind, Lords. The unless order extended the time to service, and now the defendants are suggesting that the schedule, that of course is the revised schedule, would be served by 4 p.m. on 6th of September and disclosure completed by 11th. And of course we know that in fact the revised schedule was served on the 2nd of October. So a number of points come out of these submissions. And then we see the judge's finding at paragraph 72, his summary of the fact that the failure to serve a complete and sufficient schedule was both serious and significant. And if my learned friend rather sweepingly said, well, it's clear all of this is concerned with progress to trial generally. It's not a consequence of the schedule, and therefore the judge has simply gone wrong. But if one looks closely at that, it's quite clear that the judge is focusing on the schedule in the context, of course, as he had to do of other matters.
Well, you say that the failure to serve the schedule has caused difficulties in remaining progress to trial, that it didn't achieve the outputs that the 3rd of July order was meant to achieve, and that the conduct of litigation has been disrupted by the breach of the unless order.
Correct.
And those were all perfectly proper things for the judge to take into account.
100%. Thank you.
So can I just ask you about that? The schedule had to deal with documents deleted or modified since the 24th of June.
I think that's right, yes, Madam.
I'm 18th of June, sorry.
Sorry. Right. Forgive me.
Does the judge ever deal with the question of whether matters relating to deletions or modifications since the 18th of June is going to matter?
He's dealing with it here in paragraph 72, because what he's dealing with it is, in my submission, perfectly properly, as in the way that was summarised by Lord Justice Lewis, that
Well, there's a lot about
it affects the procedure. That's what we're looking. If we just look for a moment, I'm not
Yes.
trying to duck your question, Madam, but if you look at the summary or the concluding piece of paragraph 72, which is 72G at the bottom of 27, the Court of Appeal in Denton said the question of whether the breach imperils future hearing dates or disrupts the conduct of the litigation is often a useful measure of whether the breach is serious or significant. The conduct of this litigation has been significantly disrupted, as is apparent from B, C, E and F above, and the trial date may be imperilled, and we come to that at lots of places. So
plainly the difficulties with disclosure might or might not disrupt the trial date, but does the judge ever question or address himself to whether delay in knowing about documents deleted or modified since the 18th of June is going to disrupt anything?
he makes a finding, and actually it's the subject of our respondent's notice, that, I don't want to paraphrase too broadly in case I get the words wrong, but the thrust of it is to say that in his view it may be that those documents, namely those deleted since the 18th of June, may not be that significant. He does say that. I acknowledge that.
And that's focusing on long-term significance. But specifically, does he here address himself to whether delay in producing details of those documents which have been modified or deleted since the 18th of June, which was a couple of weeks earlier,
Well,
was going to matter?
on the 31st of July was the hearing, and then 2nd of September was
But since, well, I don't know actually, the order was the 3rd of July.
the unless order was the 31st of July.
Unless the order was the 31st of July, but he has to concern himself, does he, with whether the breach of the order of the 3rd of July was likely to matter. And the order of the 3rd of July, in the relevant respect, dealt with documents deleted or modified since the 18th of June. So where does he address himself to whether that was going to matter?
Well, I think that was the answer I just gave you, that he said, the only place that I can think of, is that, and I hope saying it fairly, is that he said he didn't think, obviously looking at the matter as he did at that point, that those documents would be that, was it significant? Was it? Well, the point is this, that the judge, notwithstanding having said that, and we say, actually, with the best will in the world, he wasn't in a position to say that, because this was an obligation that hadn't been fulfilled, and therefore neither he nor the defendants, the claimants, sorry, had sight of what that would produce. So we say that was an unnecessary observation and an ill-founded one. But
Because any deletions or modifications since Judge Worcester's order would have been in contempt of court, wouldn't they?
they would have been, my lord, yes.
So we're postulating that these things have happened since Judge Worcester made his order and breach of his order.
Well, there's no doubt they did happen, my lord. It's entirely accepted that they did. There's absolutely no doubt that there was deletion of documents subsequently.
Yeah.
I can get a reference for you later, my lord, but I can assure you of that fact. But
Yes.
my point, my lord, is this. Just as the Court of Appeal said in Denton, the question of the impact of the breach on the conduct going to trial is of critical importance. Now, if you were looking at a breach of this kind, let us say right at the outset of proceedings, you might look at it one way. I still have to say that the idea that a schedule of documents whose purpose was to police two things. I'll come to this in a moment. My learned friend said yesterday, well, the purpose of the schedule was just to police the order of His Honour Judge Worcester, whereas the defendant's skeleton argument says much more accurately, in my opinion, that it was there to police the order and Schedule 2. Because obviously the integrity of the documents you're looking at depends, crucially, on this whole question of deleted documents. So it's not just a question of contempt of court. So the point is, what impact does this step have on the progress to trial?
Yes, you've made that point.
I know I have, my lord, but it was tested by a question from the bench, and so I wanted just to revisit the question about prejudice in light of that point and say that when you're approaching trial in this, in circumstances such as this, the impact on that trial and the impact on the progress to trial obviously takes on a very great significance, so that even if it's a justified judgment of a judge that doing the best he can, he doesn't think these documents are going to be relevant, those steps still have to be taken, as is acknowledged. The defendants never suggested that they didn't have to serve a revised schedule. On the contrary, they gave various promises about when it would be served, and then eventually did serve it on the 2nd of October. If you look at the, just look again quickly to the terms of the order itself, just to see how the schedule is woven into preparation, and this of course is at SB 16. You'll see from paragraph 6, which dealt with the disclosure obligations, under 6E, sorry, 6E, the parties were to seek to agree searches, etc., by 4 p.m. on 17th of July, and then give disclosure, serve lists, that is, by the 17th of August. So that was the window. And then if you go back and we remind ourselves when the schedule had to be served, that was by the 19th of July. So in other words, it was just after the agreed search terms, and the obviously envisaged structure here is that you've got the schedule, lists are being prepared over the course of a month, you have the opportunity to interrogate that schedule, ask such questions as you see fit, look to have follow-up on documents and so on. That, if we're talking about policing the order, and by that I mean in this context policing paragraph 2 of this order in particular, that's an obvious intention behind the order. That's why the timetable meshes in that way, and why it's never been suggested that because it wasn't very important we don't have to do this. On the contrary, much emphasis was placed, quite appropriately, on doing it. And I ask again rhetorically, how could it be otherwise? This is an order that the court has deemed sufficiently important to attach an unless order to it. And that goes not only to the order itself, obviously, but to the timing. That's the whole point of the unless. It has to be done in good time. So we say that whole confusion that's alleged around general disclosure issues and the specificity of the schedule and what it caused is completely misplaced. And if one reads paragraph 72 carefully, as I know your lordships have, it's quite apparent that the judge is dealing with the schedule in the context that's in front of him. And that brings us to the next point they make, which is that improperly, the judge took into account other defaults, albeit he recognised expressly that that was not what he was supposed to do at this stage of the analysis. He didn't do that. He looked at the schedule in its context. Its context was, where are we in this litigation? When is disclosure going to happen? When is the schedule going to be produced? How does that interact with witness statements? And how does that interact with preparation for trial? Those are all objective facts. That is not saying this breach becomes more serious because of that breach. I'm accumulating them. It's not. It's simply saying we need to look at it in context, which is, with respect, must be obvious. That brings us then to the second question. Was the judge right to find there was no good reason for the breach? Now, reading paragraph 39, just for your Lordship's reference of the defendant's skeleton argument, in my submission, it's not easy to discern any even suggested good reason, as opposed to the findings of breach themselves, which I address elsewhere.
Sorry, which paragraph? 30?
I think it's 37 of their, 39, forgive me, 39 of their skeleton argument.
Yes.
You see 39.2, he simply resurrects the allocation, if you like, of responsibility. And we've seen, we'll touch on again, how the judge deals with all that, but it's, my learned friend mentioned this relatively briefly yesterday, but it's quite clear from the judge's findings that he didn't find it possible at all to exonerate Ms. Williams, and that in any case he didn't feel it was an appropriate part of the analysis, quite correctly in my submission. Just bear with me a moment. And it's just this very quick point. It's in one sense not surprising when you look at what counsel for the defendants actually told the judge. I'll give you the reference. I don't think we need to turn this up, but it's, you'll see, you will have seen perhaps that you've got a transcripts bundle, and it's at page 17, C to D. And he, Mr. Atkins, says the reasons we've been over, such as they are, and that's all about Ms. Williams, etc. I'm not saying they are good reasons, but they are reasons which show to some extent anyway, this arose through circumstances beyond Ms. Williams' control. It's fair to say this specifically related to the non-Ginder accounts. But the point of it is the recognition to the judge that the fact that something may or may not be beyond Ms. Williams' control in this exercise is not a good reason. And it really is a bit of a feature of this appeal, my lord, that my lords, at various occasions, things that were said to the judge about how things should go forward, well, various things were said, and then when the judge acted consistently with those, it is said that he was wrong. Now, the judge was very careful, I have to say, but there are a number of those occasions, this is one of them. The judge was also very careful whenever he identified a concession by Mr. Atkins or a statement by Mr. Atkins to analyse the situation independently. So even if one was to say, very hard to see how one could, but if one were to say, well, the judge misunderstood or anything of that kind, he's analysed independently in any event. So then against that, what I would submit was effectively the absence of any meaningful challenge. I wonder if we could then just go back and see what the judge said here. That's, we find at paras 74 to 76, core bundle 28 to 30.
In effect, he said that Miss Williams did not give clear enough instructions to Concilio about what they were supposed to do. That's the thrust of it.
He did find that, but I think the real point is that he doesn't think anyway that that's the critical matter. The point is that what was supposed to be done wasn't done, and the defendants can't get out of that by
Well,
saying
that can't be the critical point about whether there's a good reason for what had to be done being done. The premise is that something that's ordered to be done hasn't been done, and now you want to find out, well, why hasn't it been done?
yes. But in my submission, my lord, and I didn't take the judge to look at it any differently, of itself, a misunderstanding between parties responsible for the exercise wouldn't constitute.
Yes, that's a different point.
I agree.
And that's what the judge is saying. He's saying that Miss Williams did not give clear enough instructions to Concilio.
He's certainly
And
saying
she
that.
left Concilio and Mr. Spencer to organise access to the accounts.
He is saying that, my lord. He is definitely saying that. Yeah. So that is the thrust of his the paragraph at 76, little one C1 at the top of page 29. Just check there's nothing else I wanted from. You'll see in passing here, as I've mentioned it on one or two occasions, if you go over the page, you'll see this opposite the hole punch, the top hole punch. As I say, it's unclear why Mr. Spencer didn't give Concilio access to Sam at Taylor Grange account, and then he goes on to recount the back and forth. The whole point here really is the picture he is being given is, in the judge's determination, at the very least unclear, and we see that from the above, just above that point. If you see it right at the top of the page, second line, if that is what the supplemental report is suggesting, and it is not clear that it is, then both are untrue. Concilio has been given access to Sam at taylorgrange.com account, and it does not contain, and it does contain rather, a significant number of emails identified against search terms, which were not imaged from the Sam at Future High Street Living. This is the whole debate, as your lordships will recall, about the fact that Sam at taylorgrange.com was initially thought by Ms. Williams to be empty, and therefore not imaged.
Well, thought by Concilio, I think, to be empty.
That's where she got her belief from.
Indeed, the Concilio provided that report which said no rights.
And that's what the judge has been going into, but what he's doing, more than analysing and doing the best he can with it, he's saying, as far as he's concerned, the whole position is completely unclear. Yes. Just give me a moment, my lord. So if we then just very quickly before leaving that, look at paras 45, I think, onwards of our skeleton argument at core bundle 397. In general, I can happy to leave your lordships with the reference at 43 to 50, but just pick up on a couple of points there. One in particular, which is the clarity of the order point that we see at 45. This was a point I think my learned friend also made yesterday. But,
Yes.
the appellant suggests the judge wasn't entitled to find the instructions were inadequate, instead that the error was attributable to a lack of clarity in the 3rd of July order. That, in my submission, is clearly wrong, because what it does is fail to distinguish between an order that by its nature can be reasonably complicated in the sense that there are defined terms and they have to be followed through various paragraphs of the order, all of which is perfectly comprehensible to a trained legal professional, even if sometimes it requires a little bit of thinking about that. Doesn't make an order unclear. It may be unclear in the hands of a concilio, and that's the whole point the judge is making. That the person giving instructions should bridge that gap.
Yeah.
If there is a gap. And so in my submission, the order's, it's quite simple, the order's not unclear. An order that's unclear is in essence one that's incapable of being given clarity by the court, or is requires so much construction that the person on the other end of it can't be held responsible, subject to at least to an unless order for failure to adhere to. But here we have what might be said to be a fairly standard order in this kind of situation. You have legal representatives, and you have this point, my lord, which is that, as the judge acknowledged in the judgment, the order was drafted by legal representatives of the parties, the two counsel in question. It was presented to the judge, effectively as a sort of consent, if you like. So there's nothing in the unclear order point. And I'm not going to trouble your lordships with the privileged documents cherry picking point. That's in the skeleton argument, but there's really nothing in that. And indeed, the judge didn't in the end rely on it anyway. He found he was entitled to look at that, to disregard those documents, but he didn't. And that finally brings us in relation to the all the circumstances. And that's dealt with at some length, in fact, by the judge. While we're in the judgment, though, we might as well look at it. Paras 77 onwards. And just to sort of summarise the approach, paras 77 to 94 essentially address the respective submissions. And the judge, rules on a couple of sub-points that are not important for present purposes. So we don't need to trouble too much with that. The key paragraphs really start at paragraph 94. And I suspect this is a paragraph with which your lordships are by now familiar. I hope so. It's the one where the judge says this, as mentioned in my extempore judgment of 31st July 2024, setting out the reasons for attaching the sanction to many of the paragraphs contained in the 3rd July order, the defendants at that point in time had failed to comply with a significant number of orders, namely, and he sets them out, and I don't need to take your lordships through each and every one of those, but you can see that it goes all the way through to paragraph H. So those defaults are here before the court, there's no dispute about them, save possibly to the extent that one of them may actually relate to the 3rd July order itself, but generally that's their conduct. And then your lordships see that actually goes on in 95. The number of provisions of court orders the defendants have failed to comply with is a powerful factor against granting them relief from sanction, and that is an unobjectionable and indeed, I would submit, obvious statement. And then he goes on with the point that I actually mentioned to your lordship, so it might be worth just picking up on the question of the significance of the documents after 18th of June, because that was the question I was asked whether the judge had alighted upon it. And I submitted, you'll see from 96, that the defendants have also been breaching the order of his honour Judge Worcester, requiring defendants not to delete or modify. And I referred to the second conciliar report where all those deleted documents are, my lord, just to answer that. And what the judge said at 97 was, I said to Mr. Mann, I couldn't determine now if emails have been deleted or modified in deliberate breach of the 18th of June order, or if the assertions made by Mr. Ginder about the loss of his laptop were true. And so that went on. And it is then said at 98, this I think is the direct answer to your lordship's question, I accept it's possible some of the emails have been automatically deleted from online storage accounts between 5th of July, when those accounts should have been imaged, and 21st and 22nd of August. So it only goes back as far as 5th of July there, in fairness. Whilst it's not possible to say what, if anything, of relevance has been deleted from those accounts, I doubt, as I've already said, that anything of material relevance to the claims will have been deleted between those dates.
Well, the dates I think that my lord asked you about were the dates between Judge Worcester's order.
They were actually, yes. That's why I mentioned specifically that only goes back as 5th to the 5th. So it doesn't go as far back as the Judge Worcester order. Just give me 1 second.
Do you want to go to the second conciliar report at 315, which deals with the numbers of documents deleted after the 19th of June? Lots.
Okay.
I'll maybe come back to
Miss Lewis is telling me that we can gather, which I know of course, that we can gather from the second conciliar report just how many deleted documents there were after that period. and he's just going to help me out and find the reference for that, save keeping your lordships waiting. But it's a very substantial.
Page 314.
I'm told it's page 314 of the supplemental bundle. It might be worth just a very quick look at that. What's the numbers?
I'll just hand it to you.
What page is that?
315.
So page 315, if we just go over there, your lordships will see the various amounts are identified under SAMA Future High Street Living, point 1, 1,196, and then below that, 1,174. And so it goes on. I don't think I'm going to trouble you with all of them, but it goes on over the next 3 pages.
Yes.
And for example, with Mr. Skinner at Taylor Grange, there are 11,000 and various amounts for the various other accounts. So it's a significant number, in other words. And we say that the judge wasn't entitled to make that finding, but that, I think, is an answer to your lordship's question about the extent to which he took that into account. He was looking at this much more as a procedural matter that he needed to deal with, and the fairness of the trial that could result. And then we've got, following on from there, we have what I might call conduct points. So if your lordships look at 99, I accept defendant solicitors have made promises about when they will provide evidence or information, etc. I also accept, just below this in 100, that immediately before the hearings on 31st of July, 2nd of September, defendants have filed applications, evidence, skeleton arguments very late, and then he gives examples of that. So these are all matters which were entirely appropriate for the judge to take into account. And it's specifically in 101, he says this: even if contrary to my findings, the defendants are only required to provide additional disclosure in relation to Mr. Hinder's emails accounts, I have no confidence they would do so by 11th of September, or that the schedule specifically would be provided by 6th of September 2024 in each case, as the defendants proposed, for the following reasons: deadlines missed, self-imposed deadlines missed, practice of issuing applications, etc. So he's summarising all of this conduct by reference back to the previous paragraphs. And my submission, my lord, is this, my lords, is this, that it's really hard to envisage a case in which the surrounding circumstance would point more forcefully towards not granting relief from sanctions than one in which the kind of conduct that the judge has identified here is clearly made out. The conduct that required these orders in the first place. So we obviously say that relief from sanctions should not be granted. That takes me to bound 3. And this is the strikeout ground. And the first point I'd like to make is just by reference to paragraph 43 of the defendant's skeleton argument.
Now, just before we get to paragraph 43 of the defendant's skeleton,
Yes, Lord.
what are the assumptions on which we are considering the judge's decision to strike out? Are we assuming that, as Mr. Robbins has argued, there was no breach of the unless order,
No. Oh, I see, and no breach of the 4B unless order.
any of the bits to which the unless sanctions were attached. Are we assuming that, or are we
Or is
assuming
that context? Is that really the question, that it could go to the exercise of discretion because of breaches of unless orders? Is that the
No,
thrust of the point?
I mean, if there was a breach of the unless order,
Hmm.
as the judge held, then the sanction would have taken effect.
Exactly.
And the question would have then have been, should the defendants have relief against sanctions, to which he said no.
Yes.
If he had said, there's been a breach of the unless order, I grant relief against sanctions, but I now strike out the claim, that would have been completely irrational. So I would have thought that we are approaching the strikeout on the basis that there was no breach of the unless order.
Well, I think I'd have to check. I don't want to characterise this incorrectly, but my recollection of the way the judge approached it was simply to say, well, if I'm wrong about that, in other words, on a broader level of, if I'm wrong about the consequences of the application of this order, to put it that way, neutrally, then I go on to consider strikeout. I don't believe, but I'll be correct if I'm wrong, that he analyses in a way your lordship is suggesting.
Should he have done?
My submission, I don't think that he should have done, my lord. I think it's perfectly normal, isn't it, to say, if I'm wrong about that for any reason, then it's necessary for me to go on and consider the strikeout.
Yeah. Right.
So if
Now
we
you
do
want
look
us
at
to look at the
Para 43, let's
the-
get an argument just
yeah.
quickly. We say this is a mischaracterisation of the strikeout application, where it said the judge also struck out the defences and debarred D from defending it. And note, just by reference to yesterday's little debate about what was and was not available, it's being said quite clearly here that the judge struck out the defences for breach of paragraph 2 of the 3rd of July order, to the extent they were not already struck out. That only partially characterises the application that was that the judge was dealing with. You can see from para 114 of the judgment, that's at 1241. Goes to the point we were just discussing, really, that he says, or in the alternative, an order striking out the defendant's defences and debarring them from defending the claims on pursuant to CPR 3.42 on the basis of the defendant's fundamental failure to comply with paragraph 2 of the 3rd of July order and continued non-compliance with court orders, because obviously the power in CPR 3.42 is wide in relation to breaches, and so the thrust of the application was on both grounds. One is that there has been a clear breach of paragraph 2, and that's in the context of, or allied with, connected with, a whole series of breaches of court orders.
And just to be clear, the judge had identified breaches in paragraph 94.
Yes, ma'am.
And little a went back to failure to file a witness statement in accordance with an order of the 21st of September 2022
Is the little a of
paragraph 94.
I think. Yes.
The others all relate to the 3rd of July order, I think.
Yes, but they weren't necessarily connected to the subsequent unless order, and
No, I follow that.
so,
but-
or rather,
so
I should
the-
put that differently. So they,
when one finds continued non-compliance with court orders, you're referring, are you, to Judge Worcester's order, 21st of September 2022, and to the 3rd of July order itself?
Yes, I'd have to check for us. My feeling is there are more than those, my lord, but I'll check, and if there are, I will get back to you. But that's obviously also, that's in terms of breaches of orders, yes, which is what we're concerned with here in the strikeout.
Yeah.
And just let me see if there was anything different in 101, I'll just remind myself. That was a summary by reference back to 94. So 94 is our place, I think, for finding it. But we, of course, accept that the starting point remains breach of paragraph 2. And the judge set out the terms of paragraph 2 in para 33 of his judgment. That's at CV 18, and he addressed the breach in para 34, which is at CV 19. Now, pausing just there, that I didn't understand my learned friend to suggest yesterday that there had not been a breach of the order. And Mr. Atkins accepted, even as late as his skeleton argument and grounds of appeal, and we see this from paragraph 45 of his skeleton argument, that there was what he likes to call a technical breach.
The one of the questions that my lord asked yesterday, I think he asked Mr. Robbins, was that paragraph 2 of the 3rd of July order was only directed against the third defendant.
Yeah.
So how does the judge find that the defendants failed to comply?
Yeah,
See paragraphs 118.
Absolutely. Well, I'm coming directly to that point in a moment. So could I just hold off for 2 minutes?
Yes, by all means.
And then look at it. So there's no dispute, in essence, from the other side. So my learned friend, I think it's fair to say, did distinguish between D3 and the other defendants. But Mr. Atkins never did. And there's very good reason for that, to which I'll come in a moment. But as to breach itself, in those circumstances, it may be that all I need to do is identify the judgment, say we agree with it, and there's no real challenge to it. If there are any questions around that your lordships have, of course, I'd be delighted to answer them. I know there is one question, which is the role of D3. There are some in the skeleton argument of the defendants, what I'll call discretion points. They make.
Just to be clear, in terms of breach, there was also the debate over Mr. Cohen and Mr. Skinner.
To what two actually applied? Yes, there is. Yes. That's actually the subject matter of ground 5.
So you're coming to that
specifically, later. I am. But there would have been breach anyway, as the judge makes absolutely clear. Every time he deals with this, he always says, I do believe they should have given disclosure or been proper custodians, but I make this finding in any case, because of course, there was at the very least Sam at Taylor Grange was omitted, and Sam at High Street living after 31st of January. So that substantive breach is there, come what may, but your lordship is right, that is an issue that needs to be addressed, and I'll come to it. Yeah. So just for your lordship's note for the moment, the defendants make what they call their 2nd to 5th points, which are essentially discretion points, at paragraphs 47 to 51, which I think is at, we don't need to turn it up for the moment, just for your note, which is at core bundle 346 or 347. But if we look at what the judge found about the discretionary matters, having found that the defendants did fail to comply with paragraph 2, we see that at paragraph 118 and following, on page 42 of the judgment.
Yes.
And we see in paragraph 120 this whole point about satisfied they should make, the second claimant would have made application, bar what happened with Ms. Williams. But he goes on in any case to look at the consequences of the breach of paragraph 2, and he says that they are very serious and wide-ranging because it's the breach of that paragraph that derailed the whole scheme set out in the 3rd of July order for conciliar. And that simply can't be contradicted or qualified in my submission. That paragraph 2 is at the heart of the process because it's the mechanism that creates the image, or provides for the creation of the image that is to be looked at for the purposes of the rest of the order. And so he goes on, a couple of lines later, it meant that deleted documents were only restored from, and the report upon steps taken by conciliar and the schedule he specifically mentions only related to the 1 online storage account rather than 4, and for that 1 online storage account only up to 31st of January. All of this would have to be done again in order for the scheme set out in the 3rd of July order to be completed. I've already said I'm not satisfied it could all be done again for the missing online storage accounts in time for trial, given the other directions that would need to be complied with. And importantly, whether or not the exercise extends to the email accounts of Steve Skinner and Mr. Cohen. He deals with the other matters, their good reason, quickly, because of course this is territory that he's already been over and we've looked at. And I submit that there cannot be any good reason for the failure in relation to the breach of paragraph 2. In relation to the defendant's skeleton argument on this point, these points, I did refer you just a moment ago to the skeleton on the discretion points. In essence, they weren't much taken up by Mr. Robbins, with 1 or 2 exceptions which I'll deal with orally. But we deal with those paragraphs, namely paragraphs 45 to 50 of their skeleton argument, in paragraph 52 of our skeleton argument at core bundle 401 and following. Yeah. And I'm content, if your lordships are, to leave it at that, save for a couple of specific points that I'd like to pick up.
Yes.
It's suggested in the written submissions, and I think supported by my learned friend orally, that the judge was not right to find that he could have no confidence in the disclosure exercise being completed by trial. As we know, the judge addressed this issue at various points in the judgment. We've just seen paragraph 101. We've also seen paragraph 121. And we say this, that that conclusion was more than justified by the material he had before him as to breaches of order, conduct of litigation by the defendants that we've already seen, various promises of when things were going to happen and then it didn't happen. And then if you're, I'll just refer to paragraph 48. I don't think we need to turn it up with my learned friend's skeleton argument, where they assert, as Mr. Atkins did on various occasions during the course of the trial, that it all could have been sorted. Mr. Atkins said things like, we'll stay up all night if we need to do that, and so on. Those kinds of assertions did not, of course, assist the court and don't assist the court here, nor does actually a retrospective look at what might and might not have been ultimately disclosed, because that wasn't the position facing the judge at the time. The judge was facing a very difficult situation in which the litigation was effectively, with an imminent trial, going off the rails, and he had to exercise judgment in those circumstances. I think it'd be fair to say that his assessment of the possibilities of a fair trial and disclosure taking place in good order prior to trial was an evaluative judgment. He was looking at various facts that were being presented to him, and bearing in mind, my lord, my lords, very frequently interchanges with counsel about what was going on and so on. All of which, of course, this court doesn't have access to, but it's an important part of the process as far as the first instance judge is concerned. But he was confronted by all that and had to make an evaluative decision. Now, in my submission, an evaluative judgment of that kind isn't, of course, a discretion, no suggestion, but nonetheless, an appellate court should give a quite considerable degree of latitude to a judge in the position of the trial judge here, making a decision based on that, and should not simply say, even if it were right, and I would say it could be right, but oh, well, I don't think I would have done that. That would not be, in my submission, a correct response. The judge is getting input, information from a lot of sources, changing information, changing situation, and he makes his judgment. And I would submit this: if one thing is clear from this judgment, it's that this judge took considerable time and trouble to try and arrive at a correct decision. This was not the old paradigm of a grumpy tribunal just getting a bit fed up with things and taking a step he shouldn't have taken. It's a very considered judgment, and it arrived at conclusions in my submission is perfectly entitled to look at, or to arrive at, I'm so sorry.
Might it be said that, of course, the court is very reluctant to adjourn a trial when a date for trial has been fixed. But the trial date is not intrinsically immovable. And in considering whether to strike out the defences and debar the defendants from participating in the trial, the judge has in effect considered that the trial date is immovable, and everything is judged about whether things can be completed in time for the date that has been allocated to the trial.
Yes.
And he never really thought about, well, what if I were to adjourn the trial?
Well, I think
I know I'm reluctant to do it, but it may be the only way out.
Absolutely. I think there are several answers to that, if I may. One is, I'll be correct if I'm wrong, but there was no application to adjourn the trial. And that's important, my lord, because it's not for the judge to say, no, you haven't asked for it, but I'll give it you. Secondly, one can well anticipate the reason there wasn't an application, and that is, of course, the thrust of the case law and the culture over recent years has been very much towards not the absolute inviolability of the trial date, of course, but to keeping it at all costs, and it's the parties' obligations to ensure that happens. And so, in my experience, if you were to go before a trial judge and say, "Well, I've messed up terribly, my lord, or my clients have messed up terribly, we're in breach of unless orders, everything's going wrong," it's going to be. You'd have to start with the premise that there's going to be there's no fair trial possible. Can't do a fair trial here. Could you just adjourn it, please? I think you get very short shrift indeed in the modern culture, even though, as your lordship of course rightly points out, the trial date isn't inviolable, but it's starting to get that way. Moving I would put it this way, if I may, moving the trial date is now in effect the thing of last resort. And if the reason for it is directly attributable to the conduct of one of the parties, I would submit it would be an inappropriate exercise of the court's discretion to adjourn it, and therefore, in circumstances where the judge wasn't even invited to do that, it would have been inappropriate for him to have gone out on a limb in that way. I mean, in many ways, one could almost pick up on my learned friend's submissions of yesterday. It's not there for the judge to help you out if you have, if your breaches of orders in this case have led to an outcome. It is, of course, to further the interests of justice. We know that, but we also know that in the more modern climate, interests of justice engage principles of court time, public interest, and so on, and adjourning a trial that had been fixed since I think it's January 2024. Correct. A 10-day trial as well, to go off to some point when the proceedings had begun, in fact, several years earlier.
Yeah.
I think either side seeking to make that application would have got short shrift from any reasonable judge, and therefore wouldn't be sensible for any reasonable judge to make that decision off his own bat.
Yeah.
And that point, my lord, conveniently ties in with another point they make at paragraph 50, which is should the judge have made a lesser order, e.g. imposing an unless order. It's similar in the sense that it's trying to look for alternative ways forward. And we say, if you look at the background that we've been through, and the breaches of the unless orders and so on, here the stark breach of the of paragraph 2, that the idea that you could just impose another unless order with the looming trial seems fanciful. And even if it didn't seem fanciful, here we are talking about the exercise of discretion, and that also goes to the adjournment point, of course, my lord, that what we're going to say, well, even if a given judge at a given moment in time might have seen fit to take either one of those steps, adjournment or debarring order, it certainly was not outside the generous ambit that a judge in the position of this judge had when exercising his case management discretion. And it's worth noting that, again, and it seems to happen so often, that the suggestion that was put to the judge was not the suggestion that is now part of the appeal in terms of a lesser order. The suggestion was that you judge, only debar the defendants from defending one part of the trial. And the judge perfectly correctly rejected that on the basis that you couldn't separate the issues out in that way anyway, and exercise discretion, that wasn't appropriate. But now that's morphed into, well, you should just have made a disclosure, or rather another unless order. And in my submission, that's entirely inappropriate. Again, the whole generous ambit of the discretion point. And that, all of that, I think, links to what I think was the point on which Mr. Robbins placed the greatest emphasis in this context, which was the one strike and you're out point, because it's not an unless order, as he repeatedly said. Paragraph 2 isn't, that is. And therefore, it wasn't right to adopt this one strike and you're out approach. We say that ignores the fact that the application was based on a number of established breaches of court orders and failings, if you like, in the conduct of the parties, as we've seen. Now, that's the context of the strikeout, and when you're looking at the exercise of the discretion. And in those circumstances, when you look at the sort of plethora of failings, and I use that word neutrally because there's breaches and there's late doings of this and there's promising to do that and it doesn't happen, all summarised by the judge, principally in 94 and 101. It doesn't feel right in my submission to characterise this as a one strike and you're out. It feels like they've been swinging the bat for really quite some time, and this strikeout was, in my submission, in all of the circumstances, and those of course include the looming imminent trial, was inevitable. And we know that he made that finding in various contexts, and he expressed it in various ways because it was depending on his context what he was trying to say. But he had more than sufficient material in my submission on which to base his conclusions about the impact on the fairness of the trial. Once you accept that, then in my submission, the one strike on your out essentially goes away, because you're saying right now this can't happen in my judgment, and therefore a further unless order is only going to cause further prejudice to the claimants. And just underlining that a bit, if you were to look for a moment at the second conciliar report again, just a quick dip at supplemental bundle. 307 to 8. I think
307, yeah.
yes, my lord. Just make sure I've got that right. Yes, so this just relates, your lordships will recall, there's a distinction between target documents and further documents. Further documents were documents that were produced by the 3rd of July report that were not target documents. In other words, they were not deleted documents. And so now the process has been done, if you like, at least further. You see at the top of the page 307, further documents August collection. The August collection was when the imaging exercise was carried out, including the various accounts that had not been included before. And the previous couple of 3 pages show us what happened in relation to the target documents, and there are various figures there. But look at these numbers. Further documents under Samet Taylor Grange, and there's no dispute about the Samet Taylor Grange account. Do your lordships see 72,997 further documents, 72,000? At the top of page 307.
But just to be clear, this is before you apply.
Yes, this is, and I'll make that point.
Great.
Thank you.
I was going to ask that.
Of course it is, my lord. This is just what Concilio are producing. So no search terms have been applied, but I will come to that point. But look, this is what has happened. And you'll see the very large numbers, 29,000 around the middle of the page. That's Sam at Future High Street Living. And then we have 142,000 for Peter Cohen. Over the page, we have 10,000 for Steve Skinner. And then there's another Sam account. Finally, 45,000. Now, absolutely right. All that does is create the universe of documents that have to be searched. But the judge is in the middle of this process when he's sitting there on the 2nd of September. So the date of the second report was
30th of August.
which one?
30th.
30th of August. So that is literally days before the hearing. And the judge is being asked.
And that's the report we've just been looking at, is it?
Yes, ma'am. The judge is being asked to assume that if you do this and you do that, all of these documents will be reduced down to these amounts of numbers and so on and so forth. Even the numbers they've been reduced to, with disclosure coming at the end of September and the beginning of October, those numbers are still in their thousands. That's after search terms have been applied. So my learned friend was sort of the other side of the fence yesterday, telling us how he'd spent his happy days reviewing 5,000 documents a day, and he could easily do that. But that's a very different thing from the reviewed documents themselves. That's an important distinction to make, and I accept that. Once you've got the reviewed documents and they have been disclosed, then obviously those are the things you're looking at in relation to your case. And you're not doing 5,000 a day of those in terms of taking instructions on them and seeing how they fit into the overall picture. Whichever way you cut it, this is the point. You have a judge on the 2nd of September confronted with all of this information, shifting sands as far as what the defendants say they can do. An acknowledged history of breaches, knowledge that information to the effect that when the second cut of these documents took place, there were many, many documents involved. Assurances coming from the defendants.
This goes back to your point that the judge was carrying out an evaluative judgment about how confident he could be that the disclosure exercise would be completed in time.
Absolutely, my lord.
in
And
time.
those sorts
Yes.
of numbers.
Right, I think we've got that point.
Yeah, but you haven't got the point about the amount of the
No,
numbers.
you've shown us the numbers, so we've got that point now.
And that brings us then to the question of whether the judge should only have struck out Mr. Ginder's defence, not all of the defences. There's a preliminary point, which is, before turning specific to that, which is that, of course, as I already indicated, the application was put on the basis of paragraph 2 and these various other breaches. And the other breaches were obviously all breaches, at least the majority of them, by clearly the second to sixth offenders as a whole. In other words, no question about the status of D3.
Just so we're clear, we don't have the application notice, do we, or do we?
We probably do. It's made against.
And it probably is here.
Yes, it is.
Yeah. I had the reference before, but I got rid of it.
Yes, I see it's page 61 of the first supplemental file.
Thank you, Rory. But if we look at paragraphs 122 and 124, I think, of the judgment, actually 124, I should just, it's relevant to both issues, but I should just touch on, obviously, on the question of proportionality. The judge considered proportionality expressly, paragraph 124.
The discussion, substantive discussion in the judge's judgment on this point really comes, doesn't it, between paragraphs 118 and 123. And that discussion is all about paragraph 2 of the 3rd of July order.
Well, 118, I have already found the defendants did fail to comply, and I made findings as to the extent of that failure.
That failure, that is
Yeah.
to say, the
No,
failure
that's
to
true,
comply
yes,
with
right,
paragraph 2. Where he gets to other failures in 124A.
Yes,
But up to that point, he seems to be concerned only with paragraph 2 of the 3rd of July order.
I think that's fair to say. And he did say my starting point is paragraph 2, and I accept that. I mean, obviously, the major thrust of our consideration of this issue is in relation to paragraph 2. I don't resolve from that. But going directly to that for a moment, then, in my submission, paragraph 2 does not refer only to D3 in his personal capacity. Now, just for the avoidance of any doubt, it's not just me who said that. It was also the defendants who advanced that case throughout the trial, and we see it in their skeleton argument for the 2nd of September hearing, which is at supplemental bundle 357. Seven. And you'll see it summarised at paragraph 39.1. This is the defendant's skeleton argument. Paragraph 2 of the 3rd of July order required D2 to D6 to give, etc., etc. Now, the judge reflected that in his judgment. There was never a suggestion at trial that it only applied to D3, for good reason, actually, to which I'll come in a moment. So I'm not trying to just pin it on that. But again, it comes back to the point I was making earlier. It can't be right that a party can advance a case, a positive case, not even merely not challenging something, but advance a positive case that the situation is this. And then, very much at the last minute, well, in fairness, for the purposes of the ground of appeal, simply reverts out of that. That's why it's not dealt with in the judgment. It's not there. Otherwise, the judge would have dealt with it. And if the judge had been asked to deal with it, then in my submission, and just before I make that submission, do bear in mind, my lords, that Mr. Atkins, again, was one of the architects of this order. He and counsel for the counsel at that time for the claimants. So it's not as if he's missed something here. He knows full well how this order works. And it's worth pausing on that to say that the judge obviously made the finding that he did. First, because he was right, but if you've got two parties both saying the same thing, unless you as a judge find some pretty compelling reason, you're, in my experience, going to typically go along with that. And that's the, we see that at para 34 of the judgment.
Para 34.
34.
Yeah. Oh yes, we looked at that yesterday.
The important point this time being, of course, I am satisfied the defendants have breached the requirements of paragraph 2.
Yeah.
So first point, of course, this is an appeal. They've got to say the judge was wrong. He wasn't wrong if they're saying this was the position. Also, though, there's a related point to that. They can't turn around and suggest that there's any prejudice. Let's say, well, the order's not clear, and therefore we were uncertain. So whether or not, on a strict construction, it could apply to D3 acting for the other parties, which is what I say it does. That can't apply because it wasn't clear enough for it, because they're the parties who advanced the proposition to the judge that it was all of the defendants who were in breach of paragraph 2. So there can't be any prejudice point. There can, of course, be prejudice point the other way around. This simply wasn't raised, it hasn't been raised, so the judge didn't address it. But in any case, as I say, it's correct. And it's correct for this reason. The one thing that I don't think has fully come out of the sort of various submissions that have been made so far, maybe I'm sure your lordships do have it, but I think it's important to underline it, is this. Mr. Ginder was the only individual operating in this environment. As I'll show you, he was the party charged with the whole disclosure process on behalf of the other defendants. He acted for the other defendants in all capacities. We'll see the DRD in a moment, and you'll see that the other defendants, D4, D5, D2, D6, they're not there as custodians. And the related point is this, that all of those various accounts we're talking about, Sam, at, etc., they're all him acting on behalf of a corporate entity. And why is that? Because Mr. Ginder himself had no personal involvement in the underlying transactions. Now, just to be clear on what I mean by transactions there, I mean the buying and the selling and the development or otherwise of the property, the Broad Street. He had no personal involvement. He's a party because we say he was a conspirator, amongst other things. So what's he doing when he's giving disclosure? He's always giving disclosure of either his own corporate accounts, or in the case of Cohen and Skinner, somebody else's. But how does he have access to Skinner and Cohen? Because they're not, as I understand it, please correct if I'm wrong, they're not actually doing the disclosure or the volunteering of the documents. It's because those documents are obviously on the corporate server, the Taylor Grange corporate server. And he, Mr. Ginder, has authority to go in and access that. So even when we talk about SG devices, it's been a sort of very important term as far as the defendants are concerned, because they seek by that to push everything towards Mr. Ginder in other contexts and his accounts. But the reality is they're not his accounts in inverted commas. They're the corporate accounts. And he couldn't access those accounts without the authority of those corporate entities. And we know that he had that authority from formal documents that I'll take to you just in a moment. So in my submission, that's an important picture, or start of the picture, when we're looking at what paragraph 2, I'm sorry, of the order means. And if we look, yes, excuse me, sorry. If we start just by looking at page 182 of the supplemental bundle, here I think we find the DRD. That's what I'm hoping will be there. Looks like it is. Yes. So you'll see that this is, or is this the disclosure certificate? Forgive me, it's the disclosure certificate beginning at 179. And your lordships will see at 182, I, Mr. Ginder, certify for and on behalf of the above named second to sixth defendants that I am aware of, to the best of my knowledge and belief, complied with, the second to sixth defendants' duties under practice direction 57 AD, including having, and then he sets out all the things that he's done. So he is acting on behalf of the second to sixth defendants in carrying out the disclosure obligations. And as far as we're aware, there's no other individual's heads ever popped up above the parapet to have anything to do with the conduct of the litigation. It's all Mr. Ginder. Note this as well. So it's sort of only really a collateral point, but the second to sixth defendants all offer the same defence, and they all instruct the same solicitor, and the person giving those instructions, that solicitor, is Mr. Ginder.
I haven't, of course, compared this with paragraph 2 of the order, but does what Mr. Ginder certifies on page 182 correspond with paragraph 2?
No, in paragraph 2, it simply says the third defendant. It doesn't say acting on behalf of.
No, I appreciate that.
Oh,
but in terms of the subordinate clauses here on 182, does what Mr. Ginder is required to do in paragraph 2 of the order correspond with this?
Well, not precisely, of course, because you have your disclosure obligations starting off, and that's what the certificate deals with. And then because we say disclosure wasn't carried out properly, then needs to be a 3rd of July order, initially the Worcester order, then 3rd of July order. But there's no dispute, I'll be told if different if I'm wrong, that it was always Mr. Ginder. It's he who's doing that. And then in my submission, it's a pretty obvious inference from that starting point that is the case. Your Lordship point about the wording of paragraph 2 is of course important, and I'll come to that in just a second.
That clock is 5 minutes fast.
It is
so
5 minutes fast.
if you want another 3 or 4 minutes, you can have it. But if
May
you,
I?
yes, but if you'd rather stop now, we can stop now, whichever you like.
I'm on a bit of a canter. I'll go for 2 or 3 minutes if that's all right. If it's not inconveniencing your Lordship.
No, that's fine.
Let's actually have a look at the order now.
What are we looking at?
The order of the 3rd of July, paragraph 2, page 16. Yeah. So we start at paragraph 1. Note, the second to sixth defendant shall instruct the disclosure provider as set out in this order. Now, a couple of quick points to make on that. Unless that's attributing a general responsibility, it's redundant. Because at each stage in the order, it at least appears to specify who's doing what. So it says the second to sixth defendants, for example, in paragraph 3. So to say that at the beginning would be redundant in my submission if it weren't intended to be attributing a general responsibility in this sense, that everything to do with this process is on behalf of the second to sixth defendants. Now, I fully recognise that the wording of paragraph 1 says instructed, and so it's a very easy barristery kind of submission to turn around and go, yes, well, there you are, you see. It says instructed, and paragraph 2 deals with matters other than, deals with matters other than instruction, whereas paragraph 3, for example, starts off with the heading shall instruct. But that's giving no purpose of effect to that provision in my submission, because it's there to say, in effect, all of that which is going on here is on behalf of the second to sixth defendants. But it becomes a lot clearer than that. If your lordships look at definitions, which appear at page 20, if you look at further documents mean any document recovered by e-disclosure provider under paragraph 3 or modified from 21st of October to the date the second to sixth defendants comply with paragraph 2 above. That is entirely consistent with how we say this works. It's entirely consistent with the way the defendants put the case to the judge. And it's a very strong indicator, though very far from the only one, of how that paragraph is to be read. And that also applies to target documents, if you go down below. The penultimate definition. Second to sixth defendants comply with paragraph 2 above. Now, am I saying, therefore, that you've got to read the words of paragraph 2 completely differently? You've got to read them in a way that doesn't match with what they're saying. Yes, that is simply no. It is the third defendant who's going to do those things, because he's the only human being there. But he's doing them on behalf of the second to sixth defendants. So it doesn't require any difficult reading, any putting in of significant words that in any way conflict with the form of the order. All it does is it requires a recognition of the status under which he was operating, and that status, in my submission, is beyond dispute. And not only is it beyond dispute, but this order, and I think this is why paragraph 1 was included, but you know, it's only my opinion. This order couldn't work if, when the third defendant was doing what he's doing, or being instructed to do what he was doing, carry out the steps he was doing it on behalf of those defendants. Because how can he access, for example, Cohen at Taylor Grange without the authority of those parties, and indeed the other defendants? Sorry, that's a bad example. How can he access the accounts of the other defendants unless he's acting on their behalf, at least for that purpose? And so therefore, he is acting as their agent in that respect, and they are as much liable for his defaults in that as he is. In other words, the only thing that could have been written here was acting on behalf of. But perhaps when you put in paragraph 1, you say, well, that's why paragraph 1 is there.
All right. Well, will that be a convenient moment, Mr. Mellon?
It would, my lord.
2 o'clock.
Could I just say this before your lordships rise? I have got a reasonable amount to do, so if I start to take things quite quickly,
Yes.
will you forgive me for that in advance?
Yes, of course. Right. 2 o'clock.
maybe
It's Alex that needs to send it.
one of you out to get some.
Yeah, yeah, when you're in the court, you're allowed to
No,
go to
I'll
the
give
toilet.
you a
You must wear a
shopping
nappy.
list.
Have you never booked a flight in a plane before?
Excuse me.
So you have to.
Yeah.
Jump over this side.
I'll just leave it. Yeah. Now we know we're closer, so that more can really. Wire, yeah.
And what if we don't arrange anything that I can just drop you a message or something? I can't really do that. I certainly won't feel at all surprised or whatever if you did, because I thought you've had a look.
No,
Just absolutely not.
She sends the good wishes.
Okay.
So does Emily.
Nice.
I'll decide based on that, and then whether I stay again later on, so you can drop me a message. And
Yeah, because there's various possibly I have to spend some time thinking about it. That kind of things.
when are you flying back?
Tomorrow.
Okay.
Not that much time.
Well, yeah. Well, in either case, we can see them later this evening.
We'll try. Yeah, I think we should be able to do that. As long as depending on your movements. Jump out.
It's cold.
say he's going to be referring to those documents this afternoon, so you haven't wasted your time hauling them all down.
I'm just telling you that now.
It's for enjoyment anyway, so it's all right.
The prediction yesterday was a bit. Just say yesterday's predictions and plans.
Yes, no, it's entirely possible. Just pleasant.
Is it not? They realise that. They would retake it.
Yeah, that's what I say. It's cub reporter Jimmy Olsen.
Quite good if I had to hand them down.
Except that, what was it?
I thought it might
Ask them to take a turn on the charge.
No, it's okay, thanks. Thanks, James.
No, that's all right. 58%.
Yes, Mr. Mallon.
Good afternoon, Lord. Just like to pick up on one very quick point that I missed responding to. I realised, may take a moment. I was asked a question as to whether it wasn't a bit rich for us to be, as it were, criticising the letter of instruction when we had an opportunity to look at it and make comments and so on. And I sensed that not only was it a question asked by one, but there's a slight sort of murmur of approval across the bench about that. And my answer to that is quite simple, that no, it's really not, because the relationship between, excuse me, the solicitor, the parties and Concilio and the IT experts is very much a matter for their side. So we have got neutral input in the sense that that's a letter of instruction, but in making that letter of instruction work and seeing what it needs to make it work and whether indeed it is a letter that will work, that can only really be for the defendants. The obligation is on them, but that's not to put it in a sort of formalistic, strict way. The reality on the ground, as it were, is that it's for them to ensure that what is happening is working. So that was just that point quickly. So we were on this whole question of the role of the third defendant pursuant to paragraph 2 of the order, and the fact that the order only names the third defendant in that context. And I had pointed to various documents, including the definition of further documents and target documents, where it expressly said that the definition is by reference to the date that the second to sixth defendants comply with paragraph 2.
Yes.
And your lordship's aware that my submission here is not only that paragraph 2 does refer to the third defendant acting as agent for all of the defendants, but it has to. The order simply couldn't work otherwise because of what the
Yes, you made that point before lunch.
third defendant is being asked to do. So now, if we just look at one other document, I think, in this context, which perhaps provides us with some assistance, that's the order of His Honour Judge Worcester of the 16th of June, and that's at page 11 of the supplemental bundle. It begins there, and the part I want to start with is on page 12. And you'll see that the only substantive obligation is in para 1, where it said the third defendant again note shall preserve and keep intact any disclosure documents or electronic storage media, not destroy, etc. And that was specifically an obligation and a restriction imposed on the third defendant. But if the court then looks at the penal notice,
Which notice?
the penal notice at the on the front of page 11.
Yeah.
If you, the second to sixth defendants, disobey this order, you may be held. So the point is that they are acting, or rather the third defendant again, is acting and recognised as acting on behalf of all those defendants. Otherwise those defendants couldn't possibly be in breach of the order. And the point is, or a point is, that that word is picked up really in paragraph 2 of the order at 15, one we're concerned with,
Of the unless order.
at the 3rd of July order,
3rd of July. There you are.
at page 15. Say for the purpose of giving instructions to his solicitors in connection with this order, the third defendant shall not access the electronic storage media, etc. And that's very much sort of mirroring the terms of the Worcester order. So in terms of the way it's been drafted, one can imagine perhaps that that was carried over. But the point is, in both contexts, it's quite clear, at the risk of repeating, that the third defendant is acting on behalf of all of the defendants in carrying out these actions. So, my Lord, there's no room for restricting in some way the strikeout to the third defendant. It would in any event, and it really follows from the submissions, would be artificial to do so. He is the guiding mind of all these companies. And so to somehow extract him out in one context, in a personal capacity, would be wholly unworkable in the context of this litigation, in my submission. And I do remind the court, what remains an important point in my submission, that it was never put to the judge that this was.
Yes, you told us that.
I have, and that's why I'm saying remind. That brings me to ground 5, and there's a very quick point I want to pick up at the beginning here, if I can. Just bear with me a second. In the core bundle, give me a moment to just find the page reference. Page 325. You'll see ground 5, the judge erred in law by finding in the further judgment that the appellants were required to carry out searches of the Office 365 and OneDrive accounts for Peter at Taylor Grange and Sam at Taylor Grange. So I'm not quite sure what's going on there. There are two things that are confusing, but one, the first and perhaps the most important, is that this is said to be an appeal from the further judgment, which is a judgment.
I don't think we've looked at the further judgment. This is
No,
23rd of September 2024.
and it was to do with costs and whether there was a continuing disclosure obligation. Had nothing to do with the substantive issues before us today. The skeleton argument, it is fair to say, appears to deal with the matter more conventionally, in the sense that it makes submissions about the roles of Mr. Skinner and Mr. Cohen. But there you are. That's where the appeal is said to start. So that beginning with where the judge dealt with the issue of, in effect, whether the accounts of Mr. Skinner and Mr. Cohen were covered by the order. He deals with it at paragraph 37 and following, which is page 20 of the core Bible. Under the heading, which online storage accounts should Concilio have had access to? He effectively, as it were, sets the scene in 37 and following, to 38 really, and then he records this in paragraph 39. Top of page 21, Mr. Atkins conceded that a literal interpretation of the definition of online storage accounts would mean the email accounts of the custodians identified in the DRD, and those are Mr. Ginder, Steve Skinner and Peter Cohen, all of whom had email accounts, taylorgrange.com, disclosed at the time in the DRD, plus Samet Future High Street Living. Mr. Mallon suggested the email account Simon Murray Twin. Lordships know about that. That was found against. There's no respondent's notice in respect of that. So just pause again. Mr. Atkins is telling the judge that a literal interpretation of the terms of the DRD, etc., would point to the inclusion of those accounts. Now, to be fair, he didn't say, therefore they're included. He went on to say, oh, but obviously that wasn't the intention, because everything's to do with deleted documents and Mr. Gander, so it can't be that was the intention. But the starting point of the analysis, namely what the documents actually say, was conceded by counsel for the defendants in those terms. A literal interpretation leads to that conclusion. The judge then deals with it in this way. I must first consider the wording of the definition of online storage accounts. As to that content, the defendants say the whole purpose of the exercise.
We have read this.
Right. So I'll just point out the concluding bit then. So says Mr. Atkins, the online storage accounts which Concilio were meant to be interrogating, recovering deleted documents from and preparing the report. Email account to Mr. Ginder only. And I made this point, and it's an important point, so I'm just going to read it out. I'm not going to just read it out, but I'm going to identify the point to your lordships that the 3rd of July order is concerned with broadly two elements. One is the target documents, and those are documents that had been deleted, and the others were the further documents. And I'll read the definition from here, if that's all right, from the judgment rather than take you to the order for it, which were defined as documents created or modified on or after 21st of October 2022, so essentially documents created at that point, which were not target documents, a whole separate pool of documents. And what was the purpose of that separate pool of documents? It was to bring disclosure up to date, because there had been a long lag between when disclosure was originally given. That was the purpose that the judge accepted, and there was no basis for thinking it could have any other purpose. And then the judge arrived at the conclusion in 41. It wasn't satisfied the literal interpretation of the wording leads to any different result. In other words, if you look at the wording, you get one outcome, and the context doesn't give you any reason to go anywhere else. And perhaps the important words of 41 are the 3rd of July order gives no indication that the online storage accounts for the purpose of recovering deleted documents would be any different from the online storage accounts for the purpose of bringing disclosure up to date, namely the further documents. There's an additional element here as well, which is important in my submission. If we can just go to the order again. That's at 15, I think.
Supplemental bundle, page 15.
It is, my lord, yes, thank you. Your lordships will see paragraph 3, which we'll look a bit more closely in a moment. But one of the, an important provision there is 3D. Confirm whether the SG devices are the same devices imaged reviewed by the e-disclosure provider for the purposes of second to sixth defendants giving disclosure on 11th of January 2023. So pause there. The obvious idea was that you would review and give disclosure in respect of exactly the same sources of documents as you had for original disclosure. That inevitably, as we will see, involves Mr. Skinner and Mr. Cohen, because they're on that DRD. So if we really, I mean, just to nail this completely, if you start with the definition of forensic images, they are defined as forensic electronic images taken by the e-disclosure provider in accordance with paragraph 2. Paragraph 2 requires forensic images to be taken of the electronic storage media and the online storage accounts brackets as defined. So those are our defined terms. Those things, namely the electronic storage media and the online storage accounts, are defined at SB 20 under the definitions, page 20, and they are defined by reference to the DRD.
Yes.
As you see, section 2 of the DRD is invoked in both of those
Yes.
Definitions. So if you then look at section 2 of the DRD, which is...
It lists amongst others Mr. Cohen.
It does that as well, my lord, or it does do that, certainly, but there's a point to be made looking at it as well in response to a comment my friend made this morning. So if we look at 169, just to... If we go then to 170, we see subsection 2 of section 2, which is the electronic files. And I think my learned friend took your lordships to the points that 1 to the paras 5 and 6 are really the significant ones as far as electronic documents are concerned. And then you go over to 170. So I just lost the. Just trying to find the custodians, and I've misplaced them for second 3. 173.
173, a custodian.
Sorry, thank you very much. Just pass straight over them. Oh yes. So we see here the custodians, and 3 of them are named. And then after that, and this is a point my learned friend made, that well, you've got 4, 5, 6, 7, and 8. And so he asked rhetorically, well, if the order was supposed to apply with equal force to Skinner and Cohen, as it did to Mr. Ginder, why didn't it apply to all these? And obviously the thrust of that was to say, well, it couldn't. That doesn't make any sense. But that actually goes to the heart of the issue in a way. Mr. Ginder sits there in control of the corporate servers, the corporate accounts, if you like. So he can access Cohen at Taylor Grange, as he can Steve Skinner, because they're part of the company's database, the company's data. Mr. Ginder hasn't got any control over Shoesmiths or Knight Frank, etc. So the sort of rhetorical point, well, what would happen? And so if you know, why, in other words, don't you include these accounts, doesn't make sense in context.
So that would suggest that a literal interpretation is not the right one.
No, because the order is against the second to sixth defendants. So they can't access that which they've got no access to.
So would that apply to Mr. Ginder if he didn't have the login details, for instance, for Mr. Skinner?
No, because he would have, whether he had them to hand or he didn't have them to hand, he, as an agent, an officer of the company, would have the right to access those accounts. And moreover, not just as an officer of the company, but the person expressly authorised to deal with the disclosure process, as we saw earlier on, as I know you recall. So those accounts are completely separate. They've got nothing to do with it. They've got nothing to do with an order against the second to sixth defendants.
So the legal proposition is twofold, is it? As an officer of the company, Mr. Ginder had the legal right to access email accounts operated by anybody in the company, any employee in the company? Is that proposition?
Doesn't have to go that far, my lord. It goes as far as saying that he had authority, because I don't know the ins and outs of any restrictions on his authority, but he had the authority, both express and implied, if you like, by the whole course of dealing, to carry out the disclosure exercise on behalf of those defendants,
Of the
those corporate defendants.
Yes.
And each of those corporate defendants had obviously their own servers and their own documents on those servers, or however the thing was structured. I'm not sure, did I answer your question then?
I have an answer, thank you.
Meaning not the one that satisfies your lordship, but is there? I would like to.
One way or the other.
Well, if there's anything further on that your lordship
Yeah.
would like to ask, I would happily try and respond. But the point is this: in any event, there is a clear distinction between the accounts of Cohen, Skinner, and Ginder, and these other accounts, which are not accounts of the defendants at all. And what, as you recall, 6D was doing, 6D of the 3rd of July order, was to say, you've got to go through the same process. Now, subject to one point my learned friend made this morning, there is no dispute that disclosure took place against those accounts. Now, my learned friend made the point this morning, hadn't been made before, by reference to the, I think the disclosure certificate, that Mr. Cohen had been withdrawn, in inverted commas, as a custodian because either limited or no relevant documents had been found there that couldn't be found elsewhere, and that appeared on the disclosure certificate. But for these purposes, in my submission, that makes no difference, because that's a unilateral act by the defendants carrying out their disclosure at that point in time. Mr. Cohen is not removed from the DRD, so the ongoing obligations going forward are not changed by that fact. Let's assume it was, I'm not challenging it as the correct thing to do. I have no idea it was the right thing to do at the time or it wasn't the right thing to do. But it doesn't change the fact that if you work through the definitions and you identify who's to give disclosure, the mere fact that on an earlier phase of disclosure there were no significant documents doesn't change the obligation that arises later by reference to the DRD. And the judge was really quite strict about that, because I made the point, as your lordship's would have seen, that Mr. Simon Murray Twin in effect became a custodian. Everybody accepted that he was, he gave disclosure, but the judge declined the invitation to say, therefore, in effect, he had become part of the DID. Well, he's not there, and that's not challenged. That was the decision the judge made. The other side of that coin is Mr. Cohen is there, and it's not as if he's simply ceased in some formal way to be a custodian. He's identified and he is subject to the order as the judge found.
Yes.
So the only really substantive point that is made against this interpretation, especially when you start from the concession that on a literal interpretation, it must cover Mr. Cohen and Mr. Skinner, is to say, well, that wasn't the idea. The idea of the order was all directed towards Mr. Ginder. And you can see that for various reasons, principally target documents, but also the use of the definition SG devices. As the judge found, and we support his finding on this entirely, there were two parallel paths to the order of taking you to the definition of further documents. And the other point related to that is that SG devices doesn't tell you anything, because SG was obviously the man who was controlling all of this process. It's this tendency to push Mr. Ginder forward almost as a personal player in all of this that it is potentially misleading in my submission. Let me just check behind on this, see if there's anything else. Sure. Okay. So those are my submissions on, well, I'll call it the Mr. Cohen, Mr. Skinner issue, because the ground 5 is a bit odd. That takes us then, I think, to the respondent's notice. I mean, obviously there's ground 6, which is concerned with the costs issue. We set out our position briefly. The skeletons, I doubt you lordships want to hear much from me on that. We say, obviously, it was a decision the court was entitled to arrive at. The next point in our respondent's notice is that the judge should have found that the appellants were also in breach of paragraphs 3A to E and 5 of the order dated 3rd of July 2024, such that the sanction of striking out and debarral applied specifically to that order. And so we ask, in effect, for that reversal and the consequences of it. We say the consequences of finding that there was a breach of paragraph 3 in the way that we say would be an inevitable striking out under the unless order for essentially the same reasons as the judge found in respect of 4B plus 2. They're all very overlapping reasons, of course. And we do rely on findings the judge has made, even though in terms of his conclusion, we are now seeking to reverse that conclusion. So if we start again with obviously the order at 15. The relevant part reads, the second to sixth defendants on this occasion shall instruct the disclosure provider to interrogate and restore deleted items, identify target documents restored, identify any further documents, and confirm whether the SG devices, and we've just seen that provision. The consequences of the judge's finding is essentially that we said that the consequences of the judge's finding elsewhere, not specifically in this context, are that forensic images were never created. Because the judge has found breach of paragraph 2, we say that leads to the inevitable conclusion that there was no forensic image, capital F, capital I. So if we look at how that works, paragraph 2 provides for certain steps to be taken, including effective access to the electronic storage media as defined and online storage accounts. And that leads to a purposive outcome, if you like, to allow a forensic electronic image to be taken of their contents, including any deleted items which can be restored by the e-disclosure provider. And that then becomes effectively the definition of the forensic image. And then we look to how 3 bolts onto that, and we see that the second to sixth defendant shall instruct the e-disclosure provider to interrogate and restore deleted items from the forensic images. Or we say the consequence of the judge's findings as regards paragraph 2 are there can be no forensic images. So there can't be compliance with A or B or C or E, come to that. Now, Mr. Robbins says this morning, well, that just can't be right. It's a forensic image still, even if it's not complete. It's a forensic image. But when you look at that, it really makes no sense. At what point does it become a forensic image as defined? Certainly, any forensic image wouldn't be the forensic image. It only becomes the forensic image when it does what is required to be done. Otherwise, it's simply not a forensic image. So we say, on that basis, and applying the findings of the judge as regards paragraph 2, there was a breach of at least B to C and include A in that as well. So A, B, C, and D. And of course, we accept that there's a connection between paragraph paragraph 2, and paragraph 3, and indeed 4B. This is a procedure that's been mandated by the court to achieve a particular outcome, so that's not at all surprising. But that doesn't change whether there's a breach or not. And we say that this is effectively what the judge found, but simply didn't follow it through. So if we look at judgment para 76.5 at CB 29, in those circumstances, providing concilio a copy of the 3rd July order and repeating some of its terms in the instruction as to concilio was a totally inadequate means of informing concilio which online storage accounts it was to image and interrogate. She ought to have identified the online storage accounts to be imaged and interrogated by naming them in the letter of instruction, not merely by referring to what the order said. So my submission, really essentially based on analysis coupled with that finding, or just that finding on its own, you get to the conclusion that the forensic image required for the functioning of paragraph 3 never happened. And so whatever was being imaged and so on, or rather whatever was being interrogated was not the forensic image. And again, we almost know that, as it were, in practical terms, because another forensic image was created. And it wouldn't have needed to have been if this was perfectly all right. The whole functioning of para 3 requires there to be a fixed thing that you are interrogating. It's like if the order had been, produce a red book for the inspection of these pages, and you produce a green one. You just produce something that isn't the correct thing. And if that first thing had been defined as the book, you wouldn't have produced the book. It's a simple point, and it rests on findings throughout, in the sense of the same sort of analysis of the way in which the order works and the relevant findings of the judge. And it's interesting just to see for a second how the judge then actually addressed the issue itself. Having made that finding that we've just seen in paragraph 76, he actually arrived at his conclusion on this issue at 35.
Yeah.
And just get to it. Thank
Page 19.
you very much. And he concluded very quickly, I'm not however satisfied the defendants have breached 3A to E of the July order. I find this for the following reasons. Strict interpretation, sets out the order, and then at C, goes on to say, paragraph 3 requires them simply to instruct concilio. The defendants have no responsibility under that order to ensure they carried out those steps. But that's, I think, perhaps where the judge most clearly goes wrong. The proposition that we're advancing is not that it was a problem in the performance of those instructions, but that essentially the forensic image that had been created could never have permitted the correct process to have been followed. And that goes back, that's not a question of the performance, that's because the instructions don't make clear what is necessary to interrogate. So it's not, I think the judge has gone wrong there, because if he'd applied his own conclusion from paragraph 76, and not looked at it as a matter of what happened in the end, but what the only thing that could happen, in my submission he'd have arrived at a different conclusion.
So if I've understood this argument, the order requires the defendants to instruct concilio in a certain way. And you say that the purpose of the instructions is to produce a result.
Yes.
And therefore, in interpreting the obligation to instruct, that must mean instruct concilio in sufficiently clear terms to produce the desired result. Is that how you put it?
Effectively, yes.
Is there any other way you put it?
That the instructions themselves, I suppose, could have been more neutral, but coupled with, as the judge said, further oring. So instructions taken in the round, yes, I do put it that way.
One point that the judge makes here is that he ought to be applying the wording strictly. Is that something you agree with or don't agree with?
I do agree with that. And in my submission, any strict application of, in particular, the relevant definitions only points you in one place. A strict interpretation isn't the same as a reductive one, if you like. It's one that looks to the words used, follows the definitions through, and gives effect to the order. Not in a sort of underlying, vague, purposey kind of a way. Absolutely not. No, it's a strict interpretation.
If the word instruct in paragraph 3 of the order means instruct sufficiently clearly to achieve the desired result, does the sufficiency of the instruction engage what I have elsewhere called a margin of appreciation?
No, because let me just wind back a little bit from this. The submission is this, that the second to sixth defendants have to instruct the concilio, in this case, to do certain things under 3A and so on. And those things all relate to the forensic image. So the moment the forensic image, and this is why it's a before the event question, the moment the forensic image isn't what it is supposed to be, then it isn't a forensic image as defined. So at that point, unless instructions somehow override the consequence of the fact you don't have a forensic image, then a failure in 3 is inevitable. It couldn't be anything else.
I don't follow the logic of that. If I instruct my clerk to go and fetch my umbrella from my room and there isn't one, I've given the instruction, even though there is no umbrella and it can never be fulfilled.
But the difference is that in 3, what you have are defined terms that say what the relevant content of
All
the
right, but my umbrella is defined as a striped umbrella with a brass handle. And I instruct my clerk to go and fetch my umbrella from my room as defined, but there isn't one.
But if you give the instructions are, they're at the very least incomplete. They don't work. They're not functioning. Because they're not biting on the very thing they're designed to bite on.
Yeah.
But then taking the point one stage further, and this is the way that the judge addressed it elsewhere, if the instructions that are then given are not adequate, then you are in breach of my submission. So taking your lordship's example, if the clerks came back and said, well, you told me to find the pink spotted umbrella, but there was only a blue stripy one and no pink one to be found, then your instructions would be non-functional to all intents and purposes. And if you were under an order of the court to do those things, you wouldn't have complied with the order. The order should have been, go and find the pink spotty umbrella that is located near to the front door in the receptacle.
Yeah.
But if you haven't done that, then you haven't given a relevant instruction. And it has to be a relevant instruction, not just some instruction. And the relevant instruction is one that gives all of this, or rather instructs Concilio to do certain things in relation to that defined term. I don't think I can put that any differently.
Right.
Just quickly, I'll just check behind them. Just to tidy up a couple of loose ends, there's also the ground of the Respondent's notice, which challenges the judge's findings about the deleted documents. You recall I addressed your lordship briefly. I don't think we need to say anything further about that. It's a simple point to say it probably doesn't matter actually in the overall shape of the judge's judgment. But we do say that he was wrong because he had no real basis for saying there couldn't be anything of relevance, or that it's unlikely there to be anything of relevance. But I've made my submissions to your lordship on that. I think there's another costs point, and again, if I can deal with that in the same way, simply by reference to the skeleton arguments. I don't want to trouble your lordships with that. Of course, the overarching point there is discretion of the court as regards costs, etc., which your lordships are more familiar with. Just check that I'm not missing anything. No, those are my submissions.
Thank you. Mr. Lewis, do you wish to add anything?
Very well.
Mr. Robbins, do you wish to reply?
Well, yes, there are a few points that I need to cover. On Appeal 1, the first point to make is that the judge's answer on the question of breach has now gone out the window. As my lords know, the judge applied the plainly incomplete and insufficient test in a case called Gravity Highway, and at a very early stage in his submissions on Appeal 1, it became apparent that my learned friend was not seeking to support the judge's reasoning. My learned friend said he agreed with my submissions that you have to look at the order, see what it required, and ask whether it had been complied with. So the judge's reasoning on the applicability of the Gravity Highway test in this case has gone. It's not supportable. That's been conceded. Then on the construction of the order, and I'm talking about the order of the 3rd of July, in paragraph 4b, my learned friend said the schedule is defined to be a schedule containing the specified items. My lords, that's wrong. The schedule is defined to be the schedule that is to be produced by the disclosure provider. And in the final sentence of paragraph 4b, what the appellants had to provide to the other side was the schedule, which is the schedule produced by the e-disclosure provider. That's how the term is defined. That's what they did. My learned friend went so far as to say there wasn't a schedule. He said, well, either there is a schedule or there isn't one, and he said that there was never any such schedule. Well, there was. We've seen it. It's at tab 35.1 of the supplemental bundle, and it was served before the deadline contained in the unless order. It may not have been complete, but it was still a schedule within the terms of the order. My learned friend then took your lordships to the end of paragraph 56B of the judgment. For the transcript, it's core bundle page 24. I don't propose to turn it up because we've looked at it recently. It's the paragraph where the judge said, the question whether the schedule served complies with the requirements of the 3rd of July order is equally capable of objective assessment by the court by looking at what the 3rd of July order required the schedule to contain, and then at the schedule served to see if it contained what the 3rd of July order required. That reasoning contains an unarticulated but inaccurate premise. The premise is that the unless order required the defendants to ensure that the schedule contained certain things. In other words, that it required them to ensure that the schedule complied in full with each requirement. But of course, that's not what the order said. The paragraph on which my learned friend relied is therefore a perfect example of where the judge went wrong. The schedule served complies with the requirements of the 3rd of July order if it's the schedule produced by the e-disclosure provider in response to its instructions. The order doesn't say that the defendants shall give instructions to the e-disclosure provider to produce a schedule containing a complete list of items 1 to 5 and shall ensure that it does in fact contain a complete list of items 1 to 5. That's simply not the order that was made. My learned friend referred in this context to the de minimis rule, but I don't see how there'd be any room for that on the judge's approach, because completeness is binary. Either something is complete or it is not. You can't have something that is complete yet which still omits even a single item. The omission or misdescription of a single electronic document would mean that it's not complete. So there's no de minimis exception, but even if there were, it's plainly wrong to suggest that any failing by the third-party e-disclosure provider in respect of any single electronic document would result in the sanction in the unless order taking effect. The obligations were those in respect of which the defendants had to comply. They had to give the instructions and serve the schedule. I don't
You made
propose
these points in
to
the opening
repeat.
appeal.
Absolutely, I don't propose to repeat any of that. On relief from sanction, obviously I say this doesn't arise, so I'm going to keep it brief. My learned friend took your lordship to the judge's summary of the parties' submissions in the judgment and said, well, Mr. Atkins's submissions on seriousness and significance were directed towards disclosure. There was an attempt, in other words, to blame Mr. Atkins for the judge's muddle. But that's not correct or fair to Mr. Atkins. Mr. Atkins himself has dealt with this point, and my lords will have seen it in the Skelos argument that he drafted for Appeal 1 in core bundle page 340 towards the bottom of the page, in the last 3 lines, where Mr. Atkins says that the judge's summary of the parties' submissions were their submissions on the defendant's application to extend time for disclosure. This has nothing to do with the service of the schedule. So Mr. Atkins had made those submissions, but on a different point, not on the point that the judge ended up recording those submissions on. So the judge didn't summarise the submissions of Mr. Atkins on seriousness and significance. He was, when dealing with serious and significance, summarising submissions of Mr. Atkins on other matters. And that's one of the reasons why the judgment is a muddle. We still come back to the unanswered question, why should deletions or modifications since the 18th of June have any bearing on trial preparation, when the preparation of the schedule is all about policing the order of His Honour Judge Worcester? And of course, delay in knowing about documents deleted or modified since the 18th of June, whether the injunction was complied with, isn't going to affect trial preparation. There's no basis for finding that delay in knowing about documents deleted or modified since the 18th of June would prevent trial preparation. My learned friend relied on the fact that the defendant served a revised deletion schedule. He seemed to be saying that you can infer from that that the defendant understood the order to require them to do so. He seemed to be saying, in other words, that the service of a revised deletion schedule evinced some sort of understanding on the part of the defendants that the order required the schedule to be complete. He seemed to be saying that the defendants must have understood the order to require the schedule to be complete, because when it was discovered to be incomplete, they served a further version of it. But that's a bad point. The judge's decision was on the 13th of September. The judge held that the defendants were in breach by not serving a complete schedule. He held that the existing order required them to ensure that it was complete, so they served a revised deletion schedule on the 2nd of October after that decision. They simply did what the judge had told them the orders required them to do, so that point doesn't go anywhere. Then on good reason, I made my submission yesterday, I'm not going to repeat them. The only new points to deal with, in response to the "it's a bit rich" question, my learned friend said that the wording of the letter of instruction was not really a matter for the claimant's solicitors, but in fact, the order of the 3rd of July required the claimant's solicitors to review it and comment on it. We haven't looked at it specifically, but that's what paragraph 4A says. They were expressly required to review it and comment on it.
Just remind myself of that.
That's SB 6, page 16.
Yeah.
Is there evidence that they actually did so? Did they come back with track changes?
Yes, we saw it yesterday.
Yeah,
Yes.
we saw that in the bundle. There
Yes.
were very few track changes.
Yes.
Yeah.
Then the judge's comment on Concilier's supplemental report in the core bundle, page 29, in subparagraph D, where
So just pausing for a moment on paragraph 4A, it's not just that they must provide the draft, claimants to provide comment, and the defendants must give effect to the comments in the final instructions.
yes,
So that contemplates, does it, that the instructions to the e-disclosure provider will be agreed instructions?
yes. And in practice, there was one point that wasn't agreed. I think it was to do with the laptop. That went to the judge who ruled on it. And then it was, the final version was, I think it's a bit of an exaggeration possibly to say settled by the court, because it was only settled on that one point. It was otherwise agreed. Yeah. And then in the core bundle at 29D, it's at page 29, sub-paragraph D at the bottom of the page, where the judge deals with Concilier's supplemental report.
Sorry, just a minute, not core bundle.
Page 29, my lord, D at the bottom of the page.
Yes.
There's a suggestion by Concilier in their supplemental report that they may not have imaged the Sam Taylor Grange account because Mr. Spencer told them that that account had been migrated to Sam Future High Street Living.com account, implying perhaps that he could no longer give them access to that account, or that everything that was in the Sam Taylor Grange.com account now appeared in the Sam High Street Future Living.com account. And then the judge says, if that is what the supplemental report is suggesting, and it's not clear that it is, then both are untrue. Well, yes, both are untrue in the sense that Concilier's initial understanding, based on what Mr. Spencer had told them, had later turned out to be incorrect. They'd been labouring under a misapprehension, but that doesn't touch on whether or not there was a good reason. The judge is just saying, well, their initial understanding of the position was wrong. I mean, untrue is a bit of a tendentious way to to put it, but they had laboured under a misapprehension, or under perhaps we could say false belief. They then discovered the reality of the position. There was a separate copy of the account with data in it. They copied that, but none of that touches on good reason. Then on strikeout, the premise obviously has to be that there's been no breach of the unless order. It's impossible for the unless order to have been breached and yet for the sanction of striking out to have not taken effect. My learned friend said the judge approached it on a broader basis, but that doesn't make any sense. You can only deal with it on the assumption that there's been no breach of the unless order. As regards the judge's focus on paragraph 2 and the imaging obligation, as regards the instructions, my learned friend took your lordship to as regards the other side's failure to apply for an unless order in respect of paragraph 2. My learned friend took your lordship to a witness statement of Ms. Williams dated the 29th of August in the supplemental bundle at tab 19. But the other side can't have relied on that witness statement from late August when making their decision not to seek an unless order in respect to paragraph 2 in late July. The document to which my learned friend presumably intended to refer was the email of the 21st of July, tab 32, which is the email that says devices, not, as the judge said, devices and online accounts. And then my Lord Justice Lewison pointed out the bulk of the judge's reasoning on strikeout relates to paragraph 2 of the order of the 3rd of July. And of course, yes, there had been problems complying with that paragraph, but it had been complied with by the time of the hearing before him. So it was a case of late compliance, not non-compliance, and for the good reasons explained in Concilio's supplemental report. The final thing on strikeout that I need to deal with is in core bundle page 43. The judge's summary of his reasons for concluding that strikeout was proportionate in paragraph 124. And just to summarise where I say we get to, A is the number of breaches of orders committed by the defendant, see paragraph 94. Well, this isn't a case of a long history of breaches. In paragraph 94, they all relate with one exception to paragraph 2 of the 3rd of July order, or at least the 3rd of July order. And as regards the imaging, there had been compliance by the time of the hearing before the judge. As regards the further disclosure exercise, it was well underway. For B, the judge finds that the disclosure exercise could not be completed in time for trial. That is based on his conclusion that it includes Mr. Skinner and Mr. Cohen, which taints his assessment on that point. C is it's not appropriate to vary the disclosure obligations. Well, that's plainly wrong because it's nothing to do with variation of the order. In fact, it's implementation of paragraph 7, which expressly mandates the process that Ms. Williams was seeking to engage in. And then D, even if I did vary the defendant's obligation, I was wrong, they only extended to Mr. Ginder's. I was not confident even then disclosure could be completed in time for the remaining directions to be carried out in time for trial. That is plainly wrong. It plainly, as matters stood before the judge, could be done. The position at that time was that the keywords had been applied to the very large universe that my learned friend sought to describe by reference to the supplemental report. The keywords had given rise to 4,444 documents from Mr. Ginder's emails. Those could easily be cut down in the way described by Ms. Williams by reference to the subject matter of the emails. That gave rise to a reduced total of 2,224 documents. As I said, and I'm not going to repeat it, that could easily have been done in time for trial. And of course, the proof for the pudding is in the eating. It was done in time for trial. 2,187 documents from Mr. Ginder's devices and online accounts were disclosed on the 28th of September. And Shakespeare Martinet have confirmed that they reviewed them in good time for the start of the trial.
That. But
So-
do you accept or do you challenge the proposition that what the judge said in subparagraph D was an evaluative judgment?
It was an evaluative judgment, and it's vitiated by the error that he's made. He's come to a conclusion that is plainly wrong. It was not a conclusion that was reasonably open to him on the facts. It's not the case
Is that because of the Cohen-Skinner point?
in part, but even, he says, even if it extended only to Mr. Ginder's accounts, it's not reasonably open to him to conclude that it's not possible to do it in time for trial. It's
But
plainly...
Do you not have to say that that is a view that no rational judge could form?
I do, and I did say that yesterday, my lord. It is
You
not
put it that high.
I do, yes. Not because I have to, but because it is, in my submission, the correct answer. There's only a few thousand documents, however you look at it, and it was eminently doable. It was done. Not only did they disclose the additional Ginder documents, but they also reviewed and disclosed in good time for trial additional Skinner and Cohen documents. So they actually went above and beyond what was required. The fact there was time to do more than required shows there clearly was time to do the more limited exercise actually required by the order. And as a result, we say the judge jumped straight to what should have been a last resort. This is a further vitiating factor in the evaluative decision. The judge didn't consider other options, including unless orders. And I do stress that that is the obvious proportionate solution to what the judge considered to be the problem that faced him. He said he wasn't sure that the further disclosure exercise could be completed. He didn't say it definitely can't. He said he wasn't confident. Well, if he wasn't confident, he's saying, well, maybe, maybe not. If there's any uncertainty about whether the defendants could comply, he should have made an unless order. That's the obvious solution. Then it puts it in the defendant's hands. He's not saying, you might be able to do it, you might not, I'm striking you out immediately. He says, all right, I make an unless order. The strikeout sanction takes effect if, as I suspect, you can't do it. That would have been the obviously proportionate thing to do. Jumping straight to the last resort of strikeout is, we say, an error that goes outside the margin of appreciation and turns it into a conclusion which no reasonable judge could have reached. It's plainly disproportionate, draconian, and not a fair or just response to the facts as they presented themselves to the judge. Then there's a point about whether paragraph 2 of the order was confined to the third defendant. My learned friend took my lords to the defendant's skeleton argument in the supplemental bundle at page 357, paragraph 39.1, where my predecessors referred to the 2nd to 6 defendants. That's clearly a typo or a misdescription, because that's not what the order says. And if that's what led the judge into error, then this is the opportunity to correct such an obvious error. The fact that Mr. Ginder signed a disclosure certificate on behalf of the corporate defendants doesn't have any bearing on paragraph 2 of the order, which says what it says. The fact that if it had applied to others, he would have been the natural person dealing with it on their behalf, doesn't actually tell you anything about what paragraph 2 says or means. The reason it was confined to Mr. Ginder is, of course, because this all began with concerns about what was described as his deletion practice. Paragraph 1 of the order, as my learned friend pointed out, says the 2nd to 6 defendants shall instruct the e-disclosure provider as set out in the order. My lord, it's not a barristery sort of submission, as my learned friend described it, to approach the task of construction by looking at what paragraph 2 actually says. And paragraph 2 doesn't require any instructions to be given. So whatever paragraph 1 means, it doesn't have any bearing on the construction of paragraph 2, which is about giving effective access. My learned friend took my lords to various defined terms which do contain in some respect infelicities, but my learned friend is effectively inviting your lordships to conclude that the tail should wag the dog. The controlling clause is paragraph 2, and the third defendant means what it says. My learned friend also pointed to the penal notice on the front of the injunction of His Honour Judge Worcester, which refers to corporate defendants, and it is therefore wider than the injunction against deletion, which applied to Mr. Ginder alone. My learned friend is again trying to get the tail to wag the dog, but at one remove. He's trying to get the tail of one dog to wag a different dog. The contents of the injunction have no bearing on the meaning of the third defendant in paragraph 2 of the order of the 3rd of July. Then we've got the question of whether the imaging obligation extended to Mr. Skinner and Co. And I don't propose to go over all this again. The correct answer is clear. I do think I need to deal with ground 5, the reference to further judgment as a capitalised term. That's clearly an error. My learned friends make the point themselves in their skeleton argument on Appeal 1. They say it wasn't dealt with in the further judgment. And the Appellant's skeleton argument on Appeal 1 makes clear that it's dealing with the judge's conclusions about the scope of the imaging obligation in the judgment that we've been looking at so closely of the, I think it's 13th
I
of...
thought they said in the closing argument was something to do with costs.
The further judgment is all about costs. Well, and it's about also whether the defendants have to continue to comply with the...
Have we got the further judgment?
Yes,
Where is it?
it's in the core bundle, and
There's page 48, is it?
yes, and it's not really got any relevance to anything. Judgment on written submissions.
Yeah.
But the appellant skeleton argument makes clear that it's not about the further judgment, it's about the judge's decision regarding the scope of the imaging obligation. So unless my lords have any further questions for me on Appeal 1, I was going to move on to Appeal 2.
Mhm.
My learned friend in his submissions focused on what he described as the concept of a loss of a right. He described it as a right having value. That is, of course, not how it's pleaded. It is pleaded as loss of 50% of the profits that the second defendant would have made. And I should take my lords to this in the core bundle because we haven't focused on it before now. It's page 193. And it's the final sentence of subparagraph 3. And it's unequivocal towards the top of the page. Page 193. The second claimant shall quantify its claim by reference to 50% of the profits which would have been realised by the second defendant in the above counterfactual situations. So the way in which it's pleaded is absolutely clear. My learned friend kept saying this morning, in answer to questions, if I could start afresh with a clean sheet. But that's not possible. He's stuck with his pleaded case. We've seen how it's been pleaded. My learned friend explained this morning how he says it should have occurred. Well, that's not what was pleaded. But even if you could conceptualise this within the terms of the pleadings as a loss of a right, then it's the loss of a right to a contingent payment. On my learned friend's way of putting the case, it would still be necessary to decide whether the contingency would occur. The payment to his client is contingent on there being profits, and profits still depend on one of the counterfactuals happening at a cost which is lower than the realisations. And my learned friend gave the game away yesterday repeatedly. In the transcript, page 146, lines 16 to 17, he referred to a potentially valuable right. Page 164, lines 6 to 7, he referred to something at least potentially capable of having value. Well, yes, potentially, so maybe not. The claimant had the burden of proving there would have been profits, and it didn't discharge that burden. My learned friend said, again, transcript, page 166, lines 15 to 16, that the rights of which Sandman was deprived are valuable by reference to the inherent value that derives from their potential to make profits. But again, my learned friend is assuming the potential, not seeking to prove it. And I think I do need to deal briefly with the concept of loss of a chance. As my lords have seen, before the judge, my learned friend disavowed any reliance on the legal concept of loss of a chance. And I thought we ended up in the same place yesterday with my learned friend again disavowing any reliance on the legal concept of loss of a chance. But this morning, my learned friend seemed to pivot back towards it, and he mentioned Allied Maples and Simmons in that context.
I think I only mentioned it because my learned friend sent me a copy of it yesterday. I'm not disavowing anything.
Right,
My
yeah.
analysis of the impact of loss of a chance and counterfactuals and so on, as regards the substantive tort and the quantification issue, are exactly as I said to the court
Right.
yesterday.
I'm still not sure. Would it be helpful for my lords to hear from me on loss of a chance or not? I don't want to waste time if it's
Well, if it's not being relied on, it's not being relied on.
Unnecessary. Well, in which case think I can skip over that. In any event, I was going to make the point that if my learned friend were seeking to rely on it, it's not open to him because it's not pleaded in that way, and it's not how my learned friend put it to the judge. But
Yeah.
he's not relying on it now either.
Can I give you a completely different example? Let us suppose that a disappointed client sues their solicitor, and the complaint is, on the sale of this piece of property, you failed to include an overage clause. And that would have given me 50% of any uplift in value if the property had been built out. Now, would you at the liability stage have to prove that that had some monetary value, or would you be able to say, well, I know it's contingent, I know that it's dependent on what profit might be made by building out this piece of land. I don't know when it's going to happen, but a valuer can value it.
I'm not going to be able to answer that, my lord, without getting into loss of chance, because the correct analysis would be the analysis in Allied Maples and Simmons.
Well, Allied Maples is talking about what would have happened in the past,
No,
isn't it?
no. Allied Maples, my lord, stands for the following propositions. When deciding whether a past event happened or not, the court applies a balance of probabilities. If there's a 51% chance that it happened and only a 49% chance that it didn't, the court will hold that it happened. Something with a 51% chance of having happened is treated as if it did happen. When deciding whether a future event might happen, the court adopts a more nuanced approach. First, if the future event depends on what the claimant would have done, then the balance of probabilities still applies.
I understand that.
If the future event depends on the hypothetical actions of third parties, the court adopts a different approach and asks first, as a matter of causation, whether the claimant has lost a real or substantive chance as opposed to a speculative one. That's a question of causation. If you surmount that hurdle, then the assignment of a percentage chance and the assessment of what 100% would have looked like is all to do with quantification. So in my Lord's example, overage would depend on showing that a third party would have bought this. If it's a swamp in the middle of nowhere, you might conclude there's no real or substantial chance of that happening. If it's prime real estate in central London, it might not be too difficult to conclude that there's a real and substantial chance unless there's some issue concerning contamination or something like that. If you surmount that hurdle in the context of causation, then you'd get on to quantification, which would require you to look at what would have been the total amount of gain for the claimant if the contingency had eventuated, and then that's discounted by reference to the percentage chance. And it might be that there was only a 20% chance of it happening. It might be that there was a much higher chance. But at that stage, it doesn't matter whether it's a 49% or 51% chance. The balance of probability has got nothing to do with it. So I think that's the answer to my Lord's question. I'm not sure it's relevant because it's not put and wasn't put to the judge by my learned friend in terms of loss of a chance, and it certainly wasn't pleaded in that way.
But your proposition then is that at the stage of causation and hence tortious liability, it is for the claimant to prove that what has been lost in terms of a contingent payment is dependent on showing that there was a substantial chance of the contingency materialising.
Yes. So if my learned friend were relying on that, my answer would be that Sandman would have had to show at the trial before the judge a real and substantial chance of one of the counterfactuals happening in such a way as to give rise to profits for division. And they'd only need to have proved one because they're pleaded in the alternative. And they couldn't have proved that it would have happened. They'd have had to show that it would have happened in such a way as to give rise for profits for division. that would have got them home on causation. And stage 2 would have been the question of simply saying, well, what would have been the total amount of profits and how much do we need to discount it by reference to the chance of it not happening? But as it's not put that way, I don't think I need to deal with it. If it had been put that way, I'd still be making the same point, which is to say that the district judge, having directed that this issue should form part of the first trial, Sandman elected to turn up without any evidence to show that there was a real and substantial chance of one of the counterfactuals happening in such a way as to give rise to profits for division. So it doesn't affect the conclusion. It still would have failed to show that it had lost a real or substantial chance as opposed to a speculative one. And there would still have been no evidential basis for the judge to hold that it had lost a real or substantial chance as opposed to a speculative one. And that leads me neatly on to the point that my learned friend made when he said that the judge found causation to be proved. And we don't need to turn it up, but my learned friend referred to paragraph 230, where 3 lines from the end, the judge said Sandman has lost 50% of the profits that 2020 would have made as purchaser of the 2 leases had it not entered into the scheme. At 266, last 2 lines, Sandman has therefore lost 50% of the profit that 2020 would have made but for the scheme. And then 267, 50% of the profit that 2020 would have made from its interest in the square had that profit not been diverted to the 4th to 6th defendants. But the judge doesn't find anywhere that the second defendant would have made any profit from the hotel site. So the loss that he's talking about is the loss of a right to 50% of such profit, if any, as might have been made, or as might be made. And that's theoretical and speculative only. It's like my Lord Justice Lewison's example, the loss of 50% of my Lord's profit from redeveloping Buckingham Palace. It's a theoretical concept without any substance behind it. If the second defendant wouldn't have made any profit, but for the wrongful transfer of the hotel site to the 4th defendant, then Sandman hasn't lost anything of any value. And the judge, as I say, doesn't actually answer the question anywhere in the judgment of whether the second defendant would have made any profit if the hotel site had not been transferred to the 4th defendant. There's no reasoning in the judgment to support anything to do with any loss of value. The closest my learned friend was able to get to show your lordships was in the core bundle at 137.
That's his inference, is it?
Inference about the defendant's expectations. He seems to infer the defendants expected to make a material profit, otherwise they would not have entered into those agreements. So it's an inference about the subjective intention or expectation or state of mind of the defendants. That's not inference about whether objectively the second defendant would have made a profit if the hotel site had not been transferred to the 4th defendant in circumstances where the 4th defendant hasn't been able to do so. The judge never answers the question, and the problem is apparent from the very next sub-paragraph, where the judge says that absent the scheme, 2020 would on the face of it have been in a position to realise any profit. Well, precisely. The question is, would there have been any profit? The judge still hasn't considered, let alone held, whether or not there would have been any profit. And I think my learned friend accepted my Lord Justice Newey's point that the judge doesn't explain anywhere in the judgment how he concluded, if he did, that the right that had been lost had any value. That's a transcript from yesterday, page 162, line 6 to 13. Mr. Mallon said, "I don't believe there's any express finding to that effect." And indeed, the judge makes clear that the issue of which counterfactual is an issue for the second trial. That's clear from the judgment and the parts of the order that we have seen. So it's clear from the judge's own reasoning. He hasn't dealt with the counterfactual at all. So he can't have found that there's been any loss of anything of value. As I said yesterday, 50% of nothing is nothing. Then we have my learned friend's preliminary point, as he called it, where he says the appeal 2 is academic. That's in the transcript of yesterday, page 182. And he says that the consequence of the judgment is that damages are to be assessed for breach of contract and tort, so that the non-proving on a balance of probabilities of those counterfactuals doesn't enter into it. You've simply not proved those things, but the fact is you have judgment for damages to be assessed, and that should just go forward to the quantification hearing, and they should be assessed. The problem with that, of course, is if my learned friend is right, then Sandman has somehow sidestepped completely the need to prove a key part of its claim. It's somehow bypassed the counterfactual issue altogether. It hasn't proved anything on causation, and my learned friend says, well, now it doesn't need to. We can just proceed straight to quantification.
It was already proved. If you are quoting me, you can't misquote. I said it's already proved as found by the judge.
I'll quote my friend exactly. So that the non-proving on a balance of probability of those counterfactuals doesn't enter it. You've simply not proved those things, but the fact is you have judgment for damages to be assessed. They should just go forward to the quantification stage. So if I understand...
Judgment includes causation.
Well, without
That's a debate between you.
Without having to prove anything. The judge, of course, ultimately did cut down the counterfactuals, and my lord saw what he said in the final sentence of paragraph 280, where he said the defendant's defences have been struck out, and so Sandman is entitled to have its loss quantified according to its primary rather than its secondary case for the hotel site. And I have to say, with the greatest respect to the judge, that that is completely illogical. He failed to adopt the correct approach. He didn't require the claimant to prove its claim, but said that in the absence of the defendants, in light of them being debarred, he would proceed as if the claimant had proved its primary claim but not its secondary claim. And that's completely illogical. I don't think I need to deal with the step-in rights, unless my lords have any questions, because it's not pleaded in that way and it wasn't relied on. Ultimately, on appeal 2, we can't get away from the fact that Sandman turned up at trial without any evidence whatsoever to prove one of the issues that the district judge had held would be determined at the trial. The judge was wrong to hold that the appropriate result was for it to get a second chance. Unless my lords have any questions for me, that's as much as I propose to say in reply.
Thank you very much, Mr. Robbins. Well, there are a lot of points raised, so it won't surprise you to learn that we will reserve our judgments. You will get drafts in the usual way. They come with a fierce embargo, which means what it says. The receipt of the draft judgments will be your opportunity to correct our English and our grammar, but not our reasoning, and not to introduce new points. And we would hope, in the light of the drafts, you will be able to agree an order disposing of both of the appeals. If you can't agree a form of order, please make short written submissions, and we will make the form of order that we consider to be appropriate. The eventual hand-down will be electronic by distribution to those on the distribution list and released to the National Archives, so there will be no need for any further attendance. Thank you all very much.